It's
I don't know Hon'ble
why it is COCT?
that is Petitioner.
Yes.
Lordship, I'm led by my learned senior, Mr. Shamanto. His car has just broken down, but he's on his way. He's coming up the stairs. Just my lord gives a short pass over.
27 minutes.
You start.
Lordship,
Sir?
he has the brief. He's coming, my lord. He's just on his way on the stairs, my lord. His car broke down actually at the entrance.
He has reached the court.
Yes, my lord. He's just downstairs. He's on his way actually.
Very good. Show us the order which has been impugned. You are for whom?
I am for the respondent. My lord.
You are for the respondent.
Union of India. My lord.
Union of India. That is all the respondents.
All right. But in this matter, my lord, during the pendency of this order, my lord, your lordship kindly says the memorandum. The scenario has been changed. The ordinance factory board has been seized. First.
Pardon? Please take the mic. Please take the mic.
Actually, my voice some problem.
Ask your junior to argue. You argue.
Some problem.
You please help him. Let him argue.
What my learned senior is trying to submit is there will be a correction in the cost title.
What happened to your card? New card or old card?
It's old. It has to be changed.
So you have been taught a lesson. Yes.
What my learned senior is trying to say is that there will be a correction in the cost title, Lordship, in place of in so far as respondent number 1 is concerned. 1 and 2, Lordship, it's the Ministry of Defence, Department of Defence Production and Supplies, and Chairman Ordnance Factory Board, Lordship, as per the notification that we have handed over, Lordship. In that place, it will be the DGO, Directorate of Ordnance, CNS.
All right, we shall correct it.
That
We shall correct it. You are appearing for all.
appearing for all, Lordship, all the
So, where is the order impugned? Which order was challenged by Mr. Saunto?
Lord, there are 3 orders. The OA, order in the OA, order in the review application, and in the recalling application. Lord, Lordship will kindly come
before the tribunal.
Before the tribunal.
Oh, I see.
Off karo.
What is the original order?
Original order, my lord, is at page. Order dated 6/11/2008. That is at page, my lord, 199. বিশ্বজিতের নাম দিয়ে দিয়েছো?
Complicated. The consistent stand is that you have not been superseded by anyone.
Problem is, my lord, if 6 months is there and someone is given promotion, I should have been given that same promotion because my juniors had been given the promotion 6 months earlier. According to the rules, automatically I cannot be superseded in that way, and therefore I should be given the pay scale. Now it is only a case of pay scale, nothing more.
Hmm. No, but the
Lordship will-
consistent finding of the tribunal
That is, my lord, we filed a review. The review was wrongly considered, rejected on circulation, and it is wrong. Apparently, it is wrong. Then we filed the recalling application. The recalling application was allowed, but the review rejected.
the delay was condoned.
Yes. The last order,
Your last order was to recall the review order.
yes, that was,
So that was considered on merit. And it was held that the review application has been there is nothing for the parent order to be reviewed. And the review was dismissed.
my lord, it says, it has to be kept in mind that an erroneous order decision cannot be corrected under review. They have accepted it. Page 4 of my lord, the last order.
Hmm. That an error can be corrected under review.
Nor can the tribunal sit in judgment over its own decision. They admit it is wrong. They admit it is wrong.
Admitted to the wrong to the effect that the court ought not to have considered the 91 issue in the review application. Come to the review order.
Review order is based upon something totally different. Paragraph 2.
Exactly.
Farakka barrage project, which has no connection with this matter.
That is why the order was recalled and that is why you were hard in the
Recalling application.
And the recalling
then-
application said that that 91 memo ought to have been agitated by you at the time of final disposal of the application.
But my lord, ultimately, if that is to be looked into, then my lord, I get the benefit. My lord, I'll just show your lordship one place.
Come to internal page 3 of the recalling order. Last 2 lines. The internal page 3, last line. It is not clear as to why the evidence relating to 91 as produced in review application as R1 could not be produced earlier before the court. It is also not very clear as to how the particulars of the 2 documents materially altered the process of adjudication on which the finding has been arrived at in the.
Lord, so admittedly, my lord, the document, those 2 documents, had they been considered, the matter would have been decided in a different way.
Show us that. You have to first show us how you have been superseded.
Your Lordship kindly comes to the factual statements made. Kindly comes to page 9, my lord, once.
Page 9
Page 9 of the petition.
Mr. Samanto, you are not ready.
No, I'm ready. It's there, my lord. I'm ready. Because the moment I saw that your Lordship had directed this matter to be listed as at the top, I got ready yesterday evening.
That is because you mentioned.
That's right.
We have upgraded.
Because it is so old matter. And I was telephone after telephone, what is happening to my matter? This is the problem. Your Lordship kindly comes to page 9.
রিকলিং অ্যাপ্লিকেশনটা তাই না, যে এই যে 25/11/2009 ভুল, আমরা সেটা সাইড করে দিই, করে দিয়ে বলবো যে তুমি রিকলের অ্যাপ্লিকেশনটা আবার মেডিটেট করো। এবার রিকলটা করবে কিনা সেটা প্রত্যেকে রিভিউ অ্যাপ্লিকেশনের অর্ডারটা রিকল ওইখানে, এবার রিভিউ অ্যাপ্লিকেশনটা বেঁচে গেল।
সিচুয়েশন সেটা আমরা এক্সপ্লেনেশন দিয়ে
চ্যালেঞ্জ টু order passed from review application and recalling application is to be discarded, is to be
বলো সেটাকে
ultimately এখন চ্যালেঞ্জ হওয়া উচিত না 6/11/2008।
My lord, if I can show your Lordship that
No, my brother says parent order was passed, your review application was dismissed, and the recalling application was reconsidered. The review was in fact reconsidered and order was. Suppose we find that that order is bad, then your review application survives. Suppose we accept your contention and say that the last order is a bad order, then the review survives. So who will decide the review? We cannot decide. You have to go back to the tribunal. You have filed a composite writ petition challenging the three.
no way out otherwise, my lord, because
No, there is a way out. When review is rejected, then you have to challenge the original order.
I have.
Yes. So this challenge in respect of other two orders will not
No.
serve any purpose.
That's right. No, but then, my lord, technically, unless I challenge all the orders together, what happens is there is a Supreme Court judgment that if you do not challenge the relevant orders, if the review order is not challenged, original order is challenged, then the review survives.
No.
That problem is there. That's why I have
In
made a
appeal
composite
in-
all the orders, my lord, because ultimately what happened is the OA was dismissed. It gave rise to a cause that review is filed. The review is dismissed on a wrong ground, admittedly on a wrong ground. We file a recalling application for recalling of the review order because it is patently on the face of it, it is wrong.
Yes.
It is not clear how under which provision.
Because it is relates to some other place. That recalling application, we have annexed two documents.
Generally, in code of civil procedures, we see procedure, mother procedure. The appeal has been provided if the application for review is granted. Legislature consciously has not make any provision for appeal if review is rejected.
Right.
No appeal. You know where you will find. When review application is allowed and the original application or order is modified, or varied, then you will get a right to paper appeal. Otherwise not.
That's right. But
So when indication of the legislature is that if your prayer for review is rejected, then you have no other alternative but to challenge the original.
that's why I have done so. I have done so. Now, my lordship will see why I am saying this.
Done so,
In the
but simultaneously you have challenged all the subsequent.
otherwise, my lord, what happens is in service jurisprudence, I have come across this problem.
In that circumstances, you leave your challenge against subsequent to order, subject to what we are giving liberty to, if your other side is to bring the R1 and R2
here. No,
by
it is here.
supplementary evidence.
No, it is here. Part of the records. Nothing is required except this thing.
This is part of the record of the recalling application.
That's fair. But my lord, why I am
shall
saying
not see the recalling application or review application, anything.
no, why?
Even we shall not see the order passed in review
My
application.
lord, the thing is
If
that
I say, if we hold that order passed in review application bad,
right.
so I am to send back to the original.
No, my lord. Kindly appreciate what I am trying to submit, my lord, subject to my lord's pleasure. The original order has certain infirmities, review is filed. Original order has rejected my case. Review, I have filed. Review rejected on a wrong premise. Recalling application preferred. Recalling application also rejected. Now what happened? There is a concept of merger. The first order merges the second order, the review order. To some extent, that is happening. So now, my lord,
Doctrine of merger will not.
Your lordship is having the
Doctrine of merger apply in a forum. Order passed by the trial court, then if the order, it will merge with the order of the appeal. But you are seeking review. Review is restricted.
because
review of the order, review 3 grounds. Subsequent discovery of evidence documents, error apparent on the face of the record, and sufficient review.
Yes.
3 grounds. If your prayer for review satisfy any of the grounds, you are entitled to ask the court or adjudicating authority to review.
Yes.
Otherwise not.
No.
So court held that your case does not fit, the order does not fit to be reviewed on your prayer. Challenge করলে
So far as best to order the
yes. Illegality. When given whether he has been superseded or not.
Mr. Samanto,
You-
don't press your repetition so far as the review and recalling is concerned.
Application or concerned.
We will consider your 2 documents and decide the matter finally.
Yes.
You are agreeable to that?
My lord, I'll tell you, lordship. My lord, we make many in the application, we make many statements, many prayers, etc. Ultimately, my lord,
Yeah. Go back to issue. Yes. For the use of ওইটাই এবার সাপ্লিমেন্টারি সঙ্গে হ্যাঁ সেটা নেয়নি তো না সেটা বলেছে কি ওই যে তাহলে দেখাতে হবে যে আমি ইন্সপায়ার থেকে যে কথাটা আছে না ডিউ ডিলিজেন্স, তার মানে অ্যাকসেপ্টেন্স হলো না। ওটাই আমরা ওই জন্য সাপ্লিমেন্টারি বিলটা চেয়ে নিচ্ছি। তো কালকে আসলে একটা সাপ্লিমেন্টারি এফিডেভিট আমরা নিই। ও নেয়নি বেসিক্যালি নট অন রেকর্ড, মানে একটু আমি হয়তো হাইপার টেকনিক্যাল আর কি, নট অন রেকর্ড। It has not been accepted and it has not been considered by the first forum. কিন্তু ইয়ে করবে না, সাপ্লিমেন্টারি এফিডেভিটটা চেয়ে নিয়ে আমি আমার রেকর্ডে, তাই না?
ঠিকই বলেছো,
হ্যাঁ,
কিন্তু সেটা যদি দুটো রেকর্ডিং
হ্যাঁ, একটা আমরা দেখে নিচ্ছি, আমরা ঢুকছি একটা নিয়ে এসে কালকে আমাদের রেকর্ডটা কমপ্লিট। ইউ বেটার you leave your challenge towards the recalling order passed on in recalling application and review application. And we are applying our mind to the annexure R1, R2. But to correct the record, you bring the supplementary affidavit annexing those two documents. So
R1,
that we
R2.
can take on record. We can bring on
Or
Learned Tribunal has refused to accept those documents as record, or to accept to take those documents as record.
Milord, that is the error that your lordship can always pass an order. Because, my lord,
No, Mr. Samanto, you have not understood what my brother is saying. As we are not considering the review order and the recalling order, then what happens? The record which is before us for challenging the main order in the OA, which you want to substantiate by two documents, which has not been allowed to be brought on record by the court. That is why for rectification of the records, my brother says that you file a short supplementary affidavit enclosing those two documents, and we decide the matter taking those two into consideration.
lordship,
Your main grievances.
although my lord, I appreciate what is falling from my lords, but fact is, my lord, once the record is there, your lordship can look into any part of the record under Article 226 and pass orders. I have understood what your lordship has said. Lordship will pass that on.
Learned Tribunal has not accepted your document.
That's right,
Where is your those two documents, 91 documents?
my lord.
Twenty-four.
Oh, নিজে
06.
RA1.
RA1.
R1, R2. It has been.
one is 224 and the other is
231. See, is this
224.
224 and 231.
Yes, yes.
yes?
23rd October 92 and 19 September 91.
Lordship.
Now, have you referred those two documents? You collect two documents. Those are R1 and yeah,
R1 and
91. R2 is a memo issued by 23rd October 92. Yes. The ওই দুটোই page 231, page 224 and 231.
We are considering, Mr. Samanto.
I appreciate.
Being a one supplementary affidavit,
I'll do that.
I think you'll understand. We will not give any.
Lordship will do.
What is the correction you want, Mr.? What correction you want?
Lordship, the correction in the cost title, the respondent number 1 and 2 should be renamed as. I'll hand it over to my learned senior. The respondent number 1 would be DGA, Directorate of Ordnance, CNS, and the respondent number 2 would be DDG, Field Unit, Kolkata.
No, the Union of India through Secretary to the Government of India, Ministry of Defense. It is
Lordship.
not under Ministry of Defense now.
Lordship, no, they have handed over the notification. Lordship, may I have a look at the notification?
Ministry of Defense, yes.
Lordship, the paragraph 2, Lordship, inner page 7 of the notification, if the Lordship has it.
Yes, on
But
and with
Ordnance
effect
Factory
from
Board
the above Ordnance Factory Board, which has been set up by Ministry of Defense, shall cease to exist as a body. As all the existing contracts are the new.
So now it is directly under Ministry of Defense.
Department may have been. Department may have.
Reference to the new DPSU and the Directorate.
আমাকে একটা কপি দিও।
না ওখানে You are saying that the respondent number 2, name of the respondent number
Number
2
two.
will be omitted.
No, in place of respondent number 2, it will become DDG Field Unit Kolkata.
Where
You
is
know-
that? Where from you are getting that? You have given it to him.
The copy.
তুমি ওইটা অর্ডারটা দিয়ে এই অশোক
There is a change. Definitely, there is a change.
এই এটাকে
Test 7, test
এটাকে
7.
এই পজিশনেই রেখে দাও নেক্সট আজকে কি বার ওটা ফাইনাল অর্ডার যে ওটা আচ্ছা
What Mr. Hon'ble advocate appealing for the petitioner and Mr. Hon'ble advocate appealing for the petitioner case for leave to file supplementary affidavit
on
to
record.
documents.
Documents dated
To documents, the memo, memo or order,
It's a
order.
মেমো রেন্ডাই বলে দাও
আচ্ছা, two documents,
dated 4th of
two
19
writings করলে, two writings. বলে না? But two documents are dated
19 September
19 September 1991 and
23rd October 1990
23rd October 1992. ঠিক আছে, ঠিক আছে। So bring a record. Two documents. Two documents by way of supplementary.
formally
Formally,
কেন ওটা তো আছেই না কত জন্য
আচ্ছা, ঠিক আছে, সামান্য to formally bring on record two documents and by way of supplementary petition. So, let such supplementary affidavit filed
within a week
he has
from
to
replication
he has to come from, I think, long distance. This person, he has to come from Uttar Pradesh.
No, each of
No. He is not there anymore. He is in Uttar Pradesh. And he is not well also. All those problems are there. This I suddenly remembered.
relative here
No.
who can affirm on his
No,
behalf.
Because last time he came out about 6 months back, he came from this by train. He came to Howrah, then came to my chamber. I remember. Hyderabad. He stays in Hyderabad.
Did you file any opposition to the application?
The earlier officer will have the copy has been filed. Your lot of
Affidavit? We don't have the original copy.
I got the copy because old matter minute actual advocate minute handed over copy.
to do the of course.
Exam করতে হবে।
কোনটার কথা বলছো?
কপি দিয়েছো তোমাকে?
ওটাও রাখছি।
Affidavit.
You, Mr. Samanto, get it affirmed through Todvika. Okay? So Todvika, we are
They
not
will not accept. Your lordship has to give us leave. They will not accept. Now the rules have been more stringent. Earlier we were doing it.
অত technically petition না দিয়ে
এটাই বলে শুনে। Yes, place your case.
Only the name, cause title will change what he has given.
And if it is given to
Respondent number
amend the
two.
cost structure, as paid for by Mr. Tom. Till the facts flow.
ready হয়ে আছে ready
Okay, no fact.
you tell us the facts, Mr. Samant.
Smile.
There is no list of dates you could have, because the primary challenge is paragraph 23, 24, 25, wherein you have said that you have not been superseded.
Ah.
If you can place that on the basis of a short list of dates, it will be easier for us.
I know, because those days, my lord, when this
And
was
it
filed,
doesn't seem that
it was
you have
not
been
necessary.
it doesn't seem that you have been able to go through that.
No, I'll do that, my lord. Your lordship will give me some time. I'll give a short list of dates and we'll come back. It will be better formally, because those days, my lord. Actually, what happened is those days this was not required. List of dates, etc. Even in the tribunal, it was not required. Now this is fixed, and everything has so that you can get
You
a quick.
also need some time.
I'll do it. A short list of dates, 7 days time, and lordship takes up.
You correct the cost title, you give your list of dates to your friend, and we are peremptorily fixing it as the first matter on next Wednesday. Top of the
Date
list.
Date bolo.
হ্যাঁ, ওটা বলে দিয়েছো।
কিছু নেই তো ওইটার কথা বলিনি, আমার তো ভাষা
Mr. Samant, paid for a short adjournment. ঠিক আছে। In view thereof, is the matter for further consideration on part 6 part.
6 মার্চের টপিক করে দেন।
হ্যাঁ স্যার, আমি জেরক্স
চলে গেছে পরে দিল একটু জেরক্স করে পাঠিয়ে দেবো তোমার নাম্বারটা।
ওইটা করে দাও, leave granted to guide the cost title করেছো তো? তারপর বলো party learned book is appearing for the respective parties to release the matter for further consideration on 6th under the same heading as the first matter under the same. Mr. Samanto, you ascertain in the meantime whether you can get the supplementary affidavit, 1-page supplementary affidavit, and you can get it affirmed by any relative of the person who is
No,
here.
he's not here. He stays with
You
his daughter.
ascertain,
Any relative
any relative will do.
and notary public authorization to affirm certificate copy, and with that asks him to come with such a letter of authorization.
If possible, otherwise, since the person is maybe he is very aged, let him know the fate of his dispute.
Because it is 2005 he retired.
2005 he retired, you are in
20 years.
2020.
2005, 78 now.
And Mr. Nondi, don't take any adjournment. You also assist us and prepare a copy of the opposition. You have used any reply?
Not necessary, it's pure question.
Permitted to reaffirm this affidavit.
If you can, you reaffirm in the meantime. But don't take time for
No,
that.
no.
You know, on the next date we will hear, and if you get it reaffirmed, we will take it. Otherwise, we will proceed on it. Yes, next.
Agreed.
And the list of dates you prepared and you give a advance copy to.
Sir, I'll give a relevant list of dates without anything so that only it can be pinpointed.
You do it, give a copy to him, and give our court officer a copy of it. so that we can also,
Lordship. I'll try to make it
yes, next.
pinpointed.
It is the first matter. Next item number. Yes,
May it please your lordship, my lord.
yes.
But I appear for my lord the আমার paper book টা কোনটা? But I appear for the writ petition or appellant, my lord.
Although, my lord, this is a deep,
No adjournment. Upgraded matters, no adjournment. If
if
you can do it, you do it. We will decide the
this, my
matter.
lord, a council has to appear. Bardhaman council, whether he is there.
Doesn't matter. We will let us see whether he is necessary or
It
not.
was
You are for
given
the
that
state.
For the state with Mr. Chakraborty.
Yes, place the case.
Lord, Lord, I was appointed as an assistant teacher.
Can you take us to the order impugned, Mr.
Yes.
Chakraborty?
Lord, order impugned.
99.
তুমি বসো একটু বলি
There
না?
is nothing there in the order
Lord,
impugned.
not very, Lord, everything is recorded. Lord, before I take your lordship the order impugned, may I just give your lordship 2-minute background of the matter, then I'll take your lordship. Lord, I was appointed as a teacher, Lord, in a primary school.
Just a moment. Page মিলছে না?
Page 99 is the order impugned.
But in the.
Yes, yes, I know that. That is why I was slowly taking your lordships.
All right, place it.
Lord, I
Just
was,
tell us the fact.
yes, Lord, I was working as a teacher in a school. Lord, thereafter I was promoted as a headmaster of Lord,
Secondary school,
no, primary,
primary. Then
Then,
head teacher.
yes, then head teacher. Then, my lord, in 2006, my lord, I just give you lordship the date, 9th June 2006, I submitted a letter that since I am not well, from 12th June, I prayed for leave till my recovery. 9th June, I submitted a letter. From 12th June, I sought for leave, that is page 54 to 66, along with Lord, the documents, medical documents. Lord,
Now you have retired.
no. First,
Still in
yes,
service.
yes. 1st July, a complaint is lodged against me. Criminal case. 1st July
2006.
2006.
Hmm.
Lord, 4th September, the complaint was lodged under section 409 IPC. Lord,
Hmm.
4th September 2006, disciplinary proceeding initiated. Page 50 to 52 of the paper book. I'm just giving you all of you the correct dates.
Page 50
50 to 52. Initiated.
That was the charge sheet date. 4th
Yes,
September.
yes. Then 30th May 2007, I was dismissed. That is page 67, order of dismissal.
Yes.
Now, my lord, the proceeding was initiated on the ground of my absence from the school, not on the ground of the criminal case. But when I was acquitted from the criminal case honorably, because the criminal court records, special court records, all charges, the prosecution has miserably failed to establish any of the charge against me. I was acquitted, my lord, by the criminal court on 8th December 2012, 8th October 2012. Data
8th October.
8th October 2012, page 34 to 48 of the paper book. Lord, thereafter, they reinstated me on 11th February 2013 on the ground that I am acquitted. 11th February 2013. Lord, that means that my dismissal was for this criminal case. They acquitted me, they reinstated me. They allowed me to join duty. Then I prayed under Rule 13 of the 2001 rule. That period when I was dismissed and reinstated and I was on leave, it should be treated as me on leave and I should be paid my salaries. That is rejected. And I prayed, second prayer that I made.
Wait.
I'm so sorry.
That prayer was made by you after acquittal.
After reinstatement. Lord, before reinstatement, I cannot make that prayer.
When
After
did you make that?
reinstatement. Lord, Lord, in the meantime, I tell you, Lord, my Lord, challenging the order of dismissal, I filed a writ petition. Since they reinstated me, I withdrew it. After withdrawal, I told them that since you have reinstated me, please pay me salary in terms of ROPA 2009. By this time, 2009 ROPA has come, and this period should be treated as me as on leave, and I should be paid my salaries in terms of Rule 13. That application was made
13 of the management
2001 rule. 2001 rule.
the primary
Teachers
leave rules.
leave rules. Lord,
So when did you make that prayer?
Lord, I made
When
that
was
prayer.
your writ petition withdrawn?
Lord, my writ petition was withdrawn on 19th March 2013, page 69 of the paper book. A list of date banano. But I'm sorry,
19
March 2013.
19, that is page
Lord, page 69.
69. Now, this was withdrawn by you.
Yes, because they reinstated me.
Withdrawn by you.
Yes, the court records that since the challenge has become infructuous, because I have been reinstated, the dismissal order is recalled.
Made the application for leave and that was rejected when?
Yes, Lord, I made the application. Lord, I just give you 14th May 2013, page 79. I made the application.
Yes.
Lord,
Rejected on?
that was rejected, Lord, on 5th June for the purchase. 5th June 2013. 5th June 2013 is one rejection. They said I will be paid under ROPA 98, not 2009. That is the one rejection of one prayer. I made two-fold prayer.
No, ROPA?
No. Application to
14th May 2013, I made the application that you pay me under ROPA 2009 and odd the period salary.
Now, what did they, why they rejected it on 5th June?
5th June, they said I should be paid under ROPA 98. That is one rejection. Page Lord 81.
So that was allowed.
ROPA 98.
So fundamentally, your
that leave period is not allowed. Then by a separate order, page 84, they said that is on 18th September 2013, page 84.
Where is this 5th June 2013?
5th June 2013, they also get at page 81.
81. And
then
next,
page 84, 18th September 2013. Lord, the district primary school council says that leave period cannot be, it will be without pay.
Without?
Without pay. That should be treated as without pay.
Very good. Now,
I challenging that I filed the writ petition. Now take up the impugned order. Page 91. But I just wanted to tell you, Lord, is this background so that, Lord, it is page 91. Kindly
understand.
Page 99 is the ordering portion. Most kindly got it, no? Malajasi Chatterjee has kindly got it, no? Or should I place it for your lordship? Learned counsel for the petitioner submits that the petitioner was involved in a criminal case being memory PS case number so and so. Subsequently, he was acquitted. Learned counsel submits that since he was involved in this case, his service was terminated. According to him, writ petitioner is entitled to get his salary along with all service benefits for the period he remained absent. Mr. So-and-so learned counsel, but we lost Mr. Alim Lord very recently. Learned counsel for the council submits that the writ petitioner was absent without any information to the school authority from 12 June, which is incorrect also. He submits that since he was absent for that period, authorities have passed an order to that effect that his leave proposal for absence from 1st July 2006 to 30th April 14 be treated as leave without pay and fixation pay as per ROPA 2009 and sent to sub-inspector of school for final approval. According to him, petitioner on his own remained absent. It is not due to suspension, which is also wrong. Therefore, petitioner is not in. 30th January 15 টা কোথায়? 30th January 15. 30th January 15 হচ্ছে full council dated 30th January 15.
Yes, it is not due to suspension.
Suspension. I was never put under suspension. Direct dismissal. Therefore, petitioner is not entitled to get any salary. Considered submissions made by the learned counsel appearing for the parties, it appears that the petitioner himself remained absent from 1st July 2006 to 30th April 2014. But this should be 13, not 14, because before that I joined. Should be 13. And he made proposal for granting leave with pay and also fixation of his pay as per ROPA 2009. The
You joined on 11th. You said 11th of February reinstated.
reinstated.
You joined on 30.
11th February 2013.
11th February 2013, I was reinstated. Thereafter, my lord,
You joined when?
Lord, I joined
2nd May 2013.
2nd May 2013. That is at page 78.
Then why you are saying it should be absent from?
Lord, the 30th
Yeah.
April 2014 would be wrong because I joined May 2013. This should be 2013 instead of 14. That is what I'm saying. Because 1 year back I joined
2nd May.
2nd May 13.
Yes. Then
Considering ROPA 2009, the communication made by the chairman, District Primary School Council, Bardwan, dated 30th January 2015, read as follows. The undersigned has to inform him that Deepak Kumar Bose, head teacher of so-and-so school, under his circle was reinstated in service by council memo number so-and-so, dated so-and-so, after withdrawal of his dismissal or letter dated 30th May 2007, his leave proposal for absent of those days from 1st July 2006 to 30th April 2013 as leave without pay and fixation pay according to ROPA 98 and ROPA 2009 is sent to this office for final approval from the end of the Commissioner of the School Education Department. In this connection, he is requested to send the same to the office regarding the above named teacher immediately for disposal. Lord, after recording this is not a final decision. The learned judge says, in view there is no illegality in the proposal that petitioner is not entitled to get any benefit for the period he was absent as per his own will. However, his pay fixation according to 98 and 2009 as recommended by the chairman DPSC and sub-inspector of school is directed to be made and unpaid dues, if any, to be paid. So now the only issue remains whether that period should be treated as leave with pay or without pay. Now, Lord, I'll address your lordship what is the law on this, and I'll show your lordship first, my lord, the order of dismissal, then order of reinstatement, and my lord, the rules.
now what was your prayer for the regularization of the leave by what?
Lord, kindly take that document.
You also say that you treat it as leave without pay.
I said that you treat this was a leave with pay.
Where is
Because-
that application?
Yes. Lord, kindly take me on my application.
Page 79.
79.
79.
79.
This is your application for leave. This is your representation.
Yes, Lord, kindly take me Lord, the third paragraph. Or my lord, let me place the entire thing. In this connection, I so head teacher of so circle is hereby. Lord, my lord has kindly got it, Lord, the page. As per office memo number so I have been instructed to resume my duties in the said school. Further, after withdrawing the previous impugned DPSC Bardwan dated so due to which I was dismissed from service at the time of working as head teacher of the above said school. But as there was some technical problem, I have been finally joined as head teacher of Bodia so school under so Bardwan office with effect on 25th April 2013. On 2nd May 2013 and on 1st May 2013 was holiday because of May Day, provided that the office memo number so. Then kindly take the third paragraph. You are therefore requested to take necessary action so that I may get my salary on and from 1st May 2013 in the revised scale of pay as recommended by the Pay Commission of the Government of West Bengal School Education Department. Notification dated so allowing all my CAs for 18 years and 20 years benefit as per Government of West Bengal School Education Department notification dated so as to comply with the supreme kind order provided from your office dated so second sentence.
This was not for
Brother,
your regularization.
This is for report. Then kindly take that. Then
There is no line in that you
kindly
regularize that.
take page 82. Two representations. This was for ROPA 2009. I told you, losses, two prayers I made. One they granted, the other one they refused. Now kindly take page 82. 82. এই যে আমার রিপ্রেজেন্টেটিভ মার্ক করা আছে এখানে। That at the time of working as head teacher of Koilaspur Swanso School, I had been enjoyed leave by providing medical prescription of the dated 6 June 2006 on and from 12 June 2006. But unfortunately, I was dismissed on 30th May 2007 from my service by bad in law with DPSC Bardwan office memo number so by accordingly, after receiving fit certificate from doctor on 17 July 2007, when I had been gone to join in my duty, I may not join. One of the charges against me was absent in the school for a long time without informing authority concerned. However, by another office memo DPSC dated 11th February 13, I have been again instructed to resume in my duties after withdrawing the previous office memo dated 30th May 2007, which is also reflected in the order of His Lordship the Honorable Justice Soumitra Pal dated so and so. Not only that, from para 5 of the office memo dated 11 May 2013, your supreme kind authorization has been considered at the all the charges entire previous memo with proves nothing but my clean chitness. However, as I have been received fit certificate from 17th July 2007, therefore the total period of leave enjoyed by me was 12 June 2006 till 17th July 2007. Because thereafter I was not dismissed from service. The date of dismissal 30th May 2007. Lord, June 2006, I applied for leave from 12th June until I recovered. I say 17th July, I recovered. In the meantime, 30th May, I was dismissed. Then, now at present, when I have been applied for the concerned SI, Kolabagan Circle for sanctioning my those leaves, as has been provided his supreme kind advice to me that so long the office of DPSC Bardwan has not been issued any order, the proposal order for sanctioning leave may not be issued. At present, my humble request to you to provide your supreme kind order so that the proposal order for sanctioning my leave for those 401 days only may be issued by the office of SIS Kolabagan, either as special leave with full pay under medical ground in total as per para 4H.2 or leave rules of the government of West Bengal, so primary so 1999, because my every document of taking those 401 days leave has been scrutinized by the authority before providing me to reinstate or sanctioning or out of those 401 days, 180 days leave on medical leave with full pay and rest 221 days on UL under medical ground as per the above GO, provided that although I have become ill and was under supervision of doctor on and from 6 June 2006, but at that time the school was closed due to summer vacation, so and so. So the period for which you treated me as absent and you dismissed me, you withdrew the dismissal order. This is one, Milord. Then kindly
That
take
is, the period was from
12 June 2006 till 17 July 2007.
17 July 2007, you started
No,
No.
by this time on 30th May 2007, I was Lord dismissed from service.
Yes.
Lord, June 2006, 6 June 2006, I submitted an application that I am unwell. This is the medical certificate. Allow me to take leave from 12 June until I recover. I recovered on 17 July 2007. In between, they dismissed me and they reinstated me on their own.
Reinstated when?
Reinstated me, Lord, on 11th February 2013. So the period from 2007 to 2013, I could not perform my duty because of them, because they dismissed, they reinstated me. Lord, had there been anything on the dismissal order, they would not have reinstated me. The reinstatement order, I'll show you, Lordships, it says that they are recalling the earlier order. That itself shows that the earlier order is become non-existent.
So you have never been placed under suspension?
No. No. Now, let me show you, Lordship, the document. Arekta representation.
So, representation is 86.
Lord, there is one more representation. My Lord, may kindly have a look at it, Lord.
86 পুরোটাই বলেছিলাম ওই জায়গাটা বার কর ওই জায়গাটা বার কর।
এই যে এখান থেকে বলেছে রুল 13 এর কথা।
আর আগে ওকে ডিসমিস করে দিয়েছে 30 মাত্র।
The actual period of leave enjoyed by
Lord, the
জয়েন করতে 11 দিন, তাহলে ওর লিভ যেটা এই যে আপ টু 11 জন ডিসমিসালটা চলে up to the date he was fit to join. মানে অসুস্থ ছিলাম 3 মাস, আমি ডিসমিসাল ডিসমিসালের চলে যাবো না সেম স্টেটে then procedural show us the dismissal order recalling হলো 11 দিন অ্যাডমিটের ডেট হচ্ছে গিয়ে তোমার 8-10-2000।
আমি এখন রোববার
ইস্যুটা হচ্ছে কি প্রসিডিউরের চার্জটা কি হবে? Show us the charge sheet.
Lord, only kindly pardon me. No, sir, it is 9th June. 9th June I submitted the application for leave.
Remain absent
Yes, from 12th June. 9th I said because
No.
until I recover.
Dismissal not. Dismissal
এগুলোটা পেয়ে গেল।
ওই পিরিয়ডটা থাকছে রেগুলারাইজেশন।
But I have two things.
2006 to 30th May 2007 you have got.
No. That is leave without pay.
That is leave without pay.
Yes.
Leave without pay is 12th June to 17 July.
17 July and now till 2013 also. By that period I remain under dismissal. That is also they are saying leave without pay. That's the
How
impugned
can
order.
that be leave without?
That's the impugned order. That is what is under challenge before your lordships.
They are also
Medical
saying-
leave has not been sanctioned.
Lord, I tell your lordship only one thing. Kindly
Fact is that your medical leave has not.
Lord, kindly appreciate one thing. You terminate me or dismiss me for my unauthorized absence. Then you recall that order. That means you accept that I was on regular leave.
Mr. Chakraborty, you are saying that you have to regularize my period from 12th June 2006 till the date of my reinstatement.
Absolutely. In twofold. One is till 17 July 2017. On the ground of Lord, I applied for leave. And from the date of dismissal till the date of reinstatement or 18 July till 13 February 2013 under Rule 13. Lord, kindly take page 87 for a second of the paper book
Rule 13?
of this rule,
Rule 13.
2001 rule, which says that if I am Lord honorably acquitted. Copy আছে? There is a fresh copy. Mark করা। Lord, a little mark, Lord, kindly. I'm very sorry, Lord. আমি দিয়েছি, দুটোই দিয়েছি। Kindly have a look at Rule 13.
So you have not got any benefits for the period from 18 July 2007 to 11th of February 2013, though you were reinstated.
Yes. Lord, since I'm
Just.
yes. I absolutely.
Everyone.
Absolutely in twofold. 6 to 7, then 7 to 13.
Now, where is their order of rejection of your medical leave? After this,
There was no order of rejection of the medical leave.
79, 84,
it was kept like that.
84.
It was kept like that. Lord, let me show your lordship first my application. Lord, let me show your lordship one by one chronologically the documents. Lord, if my lord so allows me, Lord, that may, Lord, kindly take me, Lord, first my application at page 54.
So it's the page 3.
Very briefly, I'll take your lordship. Page 54 kindly comes. Lord, at the bottom, your lordship will find the stamp. They received on 9th June.
Yes.
Lord, I am placing only the last paragraph. Under such circumstances, it will be impossible to me to join the school after the reopening of the school after the summer vacation, that is on and from 12th June 2006. You are therefore requested for your kind self allowing my leave after consideration my matter till my recovery, provided that doctor's prescription has been attached with my this application and my present a contact address has been given below of this application for your kind attention. It is included that due to my illness, I am sending this application through my wife and also informing my school through my another application. This was my application. Then, Lord, kindly take Lord page 50. Page 50. The charge sheet. My lord, no, this is dated 4th September 2006. Much after my application. What they are saying, they don't say that they have rejected my leave application. I submitted a leave application. They could have rejected it, then put me saying that you have not joined. That is why the charge sheet. They are saying, whereas it reveals that from the office record that Sri so has been absenting himself in his duty school with effect on 12th June, the day from which I prayed for leave, without any information. Now, the very basis of this is wrong. Then, to the concerned authority, which is contrary to the extent rule and also contrary to the interest of the primary school education of this council, and whereas vice memo dated so Sri Deepak Kumar Bose was directed to show cause with necessary disciplinary proceeding will not be initiated against him in terms of extent rule, and whereas it appears from the office
charge sheet.
This is
51.
This is
51
seeking a
50.
reply from you.
yes. Then Milord, the
Where is
charges
the-
page 51, the imputation of charges, misconduct. Whereas Deepak Kumar Bose is guilty of gross misconduct for not attending the duties, contrary to Rule 3 of the Conduct Discipline Rule 2001. Whereas from record it appears that Sri Deepak Bose has been absenting himself from his duties in the school on 12th June. Whereas from the absent of the concerned SIS, it appears Sri Bose has been absenting himself of the school. Whereas upon scrutiny of the office record, it does not transpire Sri Bose has made any application for leave. Now, Kali sees this. Clause D, page 51. Whereas it appears that Ms. Sri Bose has not made any application for leave. And whereas he is unbecoming of a primary school. On this, Milord,
no application was made to the chairman. You submitted it before the SI of school.
yes, I have submitted it to the SI of school.
Did you send it to the chairman? You did not.
No.
That thought.
Chairman, what is it? Yes,
No, it's page 54, accept.
54.
Milord, in page 54, I have said last line that I am sending another to the school through another application.
That you have
Lord, it
not-
was addressed to the chairman. The letter was addressed to the chairman, page 54. It was addressed to the chairman.
Yes.
So it was the duty of the sub-inspector to forward it to the concerned person if he has received it.
What happened?
Then, Milord, the
Extension application.
and subsequently I
No,
filed
no, come
extension
to page 52.
52. Yes, 52.
Your name.
List of documents.
Where is this letter of the SI dated 11th of August 2006? Has that been brought on record?
No affidavit has been filed by them. But then comes the order of dismissal, page 67. Page 67.
You participated in the proceeding.
Not as per, from the record, it doesn't appear that I participated. It doesn't appear.
67, what you are showing?
It's the order of dismissal. এটা participate করেছিলাম না, record থেকে বোঝা। I did not participate as it appears from the record, my lord. As it appears from the record that I did not participate because I was not well. And one more thing, if my lord sees this,
You were asked to appear in the proceeding.
yes, that was the document that I have to submit.
Show us the termination order.
It's 67. Whereas it appears from the report dated 21st June 2006. এই এদিকে পেজ 50 তে আমার যে অ্যাড্রেসটা
সেখানে সেটাই আমার অ্যাড্রেস নাকি?
Lord, may I আমাকে তো অন্য অ্যাড্রেসে পাঠিয়েছে পেজ 50 দেখ 54 এটা 0.9 বোধহয় ডিটেল ভিলেজ সুলতানপুর মেমারি বার্ড 1 আর আমি এখানে বলেছি আমার প্রেজেন্ট অ্যাড্রেস হচ্ছে শ্যামলেন্দু সরকার ভট্টাচার্যপাড়া শ্রীপল্লী বার্ড 1 তাই তো রিটেক কিছু বলেছে কি দেখতে পাইনি এরকম কিছু তাহলে পরে পেলাম করতে লাগানো আছে মনে হয় নেই একটাই বলে রিড লাগানো
So, Mr. Chakraborty, you have been reinstated on 11th of February 2013.
yes and that order is withdrawn.
Let us. We are wanting to know from you.
Lord, page 68
There were 18th of July 18th of July 2020 till 11th of February 2013 was the total period of absence, divided into two parts.
no
One is from 17 July.
little correction, Lord. 12 June 2006 till 11th February 2013 is the total period. It is divided in two parts.
Where you are getting 12th June?
Because I submitted my leave application that from 12th June I'll be absent
Very good. 12th June 2006 till
till 11th February, the day of order of reinstatement, is the total absence.
11th. Yes.
Then it is divided in two parts.
Yeah, just this is total absence. Now divided into two parts.
First is 12 June 2006 till 17 July 2007. 17 July, I say that I
Why to join?
because I say I went to join because I become fit.
It is because since you have been dismissed on 30th May,
There was no question of joining.
there is no question of
My
joining.
lord
You
may
have no
take it.
right to join.
My lord may take it that till 31st April,
31st May,
30th April,
30th,
30th April, 12 June 6 to 30th April 2007. Sorry,
30th May.
29th May 2000.
30th May.
29th May.
ওই দিন
Ah, 29th May.
29th May 2007.
And the second is 30th May till 11th February
2007 to 11th February 2013.
13.
Next is 30th May
7
2007
to 11th February 13.
June
to
11th February 13, 2013.
so far as the latter period is concerned, you will automatically be entitled to the benefits
In terms of Rule
on the
30.
basis of reinstatement.
Rule 13.
Lord,
So far as that period is concerned,
on the basis of reinstatement,
which remains unattended to that period, we will relegate to the authority. They will consider.
But I completely bow down to your lordship. Only one indulgence from your lordship. Kindly allow me to say this. With the issuance of the order of reinstatement, Lord, kindly take this situation. Why I was dismissed? I was dismissed on the premise that I was, without informing, I was being absent.
So it has to be regularized. We are not saying don't regularize that period.
Yes.
Once reinstated,
Yes,
your
that,
back
that
service
allegation goes.
continuity has
That
to be-
allegation goes.
Your back service continuity has to
Yes,
be there.
yes,
There
that's
should
my
be-
case.
There should be no break-in.
Absolutely.
Now the break-in service, how it has to be construed, how that period can be regularized, pertaining to which your claim is that I was sick. Authority will consider.
No, authority will definitely consider, but before your lordship, my submission would be that
So, Mr. Chakraborty, what remains is only for the period from June 2006 to July 2007.
But
This
if
is
your
a
lordship-
period of 1 month.
if your lord,
So,
no,
not
1
in
year,
this-
1 year, 1 year.
1 year. So, for this
If
1
your lordship
year,
allows me this period, I'll go back. I'll happily go back.
be happy that
I will happily go back. My lord allows me this period, I'll happily go back. I'll happily go back.
We cannot guarantee you leave.
No, that period pay I should get.
Yeah, we will get.
The dismissal period, that your lordship will grant me. The dismissal period.
question of granting, that is automatic. You have already got it.
No, they have not given me.
For the period, where is your representative? Then it becomes, then show us the order by which the disciplinary proceeding was pending, the order of Justice Soumitra Pal. Where is that?
Justice Pal's order is not a part of the record.
We want to see the observed.
আচ্ছা বার করতে Justice Pal's orderটা কোথায়?
His pulse order is also.
না সেটা তো withdrawal of the writ
Oh, that
petition.
is a withdrawal.
That is the withdrawal order.
Period of paint of but এইটাকে দিয়ে অনুযায়ী এই পয়সাটা কিনবে।
If I am entitled, I should get that.
Automatic consequence of
এটা হচ্ছে ওই পিরিয়ডটা, সেকেন্ড পিরিয়ড।
that is consequence of
ওটা ছাড়া জাস্টিস পালের কাছে আর কি
সব
না এখন order তো নেই। আমি withdraw করে নেই।
সেটা তো ওরা দিতে পারে।
আজকে অর্ডারটা কি লিখেছে দেখতো অর্ডারের ডেটটা কোথায় পড়লাম জাস্টিস পালের অর্ডারটা পেজ
64.
পেজ 64 পেজ 50
না সরি 64 না
72
হ্যাঁ আরে কোন একটা জায়গায় রেফার করেছে
মেডিকেল
কোন একটা জায়গাতে আমি কোন আমার চিঠিতে রেফার করেছি
জাস্টিস পাল হচ্ছে 72
চিঠিতে অর্ডার বাট রেফার ইট সামওয়্যার
82 তো দেখো ফার্স্ট প্যারাগ্রাফ
Not speak on it.
82 ফার্স্ট প্যারাগ্রাফ
অর্ডারটা দেখানো
পয়সা ওকে দিতে হবে।
এটা জাস্টিস পালস অর্ডার সুমিত পালস অর্ডার 12 March 2013
March
page 72 yes 12 March Lord Justice Pal's order which is referred that is the order of withdrawal of the writ petition not for continuation
Prior to that,
yes can you see the prayer
cancel
made in the writ petition
holding that
I have prayed for 6 to 13 prayer A page 24 in the writ petition
18 September 2013 is what is
that is the impugned order in the writ petition by which they said it will be without pay
that is at
Page-
page 84
page 84
leave was granted but
leave without pay
yes
no, I don't know.
this has to be with pay with all benefits you dismiss you withdraw and in the meantime I lose my salary
That is for pertaining to the period from
দেখুন
not the entire period this is for entire period entire
no.
period
2006
it
but
has
the
been
dismissal for yes 30th May to 7 to 13 see period to the
30th May to 11th February
yes my lord direct them to grant me that and the other one they can reconsider
আমাকে এপ্রিল পর্যন্ত দিচ্ছে
এইটাতে কোথায় এপ্রিল
জয়েন করলাম তো আমি
না সেটা তো জজ সাহেব ওই পিরিয়ড দিয়ে দেবেন
Now kindly come to page 82, your representation.
yes lord there is one more representation my lord may have a
What
look
you
at
have, what you have,
here only that period 6 to 7 here only that period 6 to 7 page 82 speaks about only that period 6 to 7
they
401 days.
They are C or sanctioning 401 and 221 days. How you get this?
401 days 180 and 221 I have divided in two parts
So
Lord,
this is
You have said the first part, medical leave with pay,
yes
and second, extraordinary leave,
yes
what is
under medical.
Under medical. and clause
as
13
per the above geo. Geo, that means 99 Geo.
My Lord Justice Chakraborty may see page 87. Rule 13 I have referred there. Rule 13 by which the dismissal period will be covered. Page 87. I have prayed for that specifically.
Page 87.
Page 87, the representation starts at 86. Take page 87.
When did you make this?
So this is post the impugned order. This is post the impugned order. Subsequent to the impugned order. Subsequent to the impugned order in the writ petition. Take the paragraph starts with but. But unfortunately, in reply to the application, represented so consequently, to Badwan so has been passed representation. Circle has been informed to prepare my leave proposal from 6 to 30th 13 without pay. That is page 89. Now humbly represent to you. It appears from Rule 13 of West Bengal Primary Education Conduct Discipline Rules, dated so pay and statement. When the suspension, I quoted Rule 13 here. Then kindly turn the page. In a case falling under clause A, the period of absence from duty shall be treated as a period spent on duty.
That is which page you are reading?
Page 88, 87, I quoted clause 13. Page 88.
Falling under clause A.
Yes.
Clause A means?
Clause A means, not kindly go back to the earlier page. If I am honorably acquitted. In a case falling under clause A, the period of absence from duty shall be treated as a period spent on duty. In a case falling under clause B, the period may be treated as on duty or leave, but it shall not be treated unless the disciplinary authority directs accordingly. The period of absence shall, where it is neither treated as on duty nor leave, be treated as a period spent on suspension. The interpretation of this rule has been cleared in the judgment of WP number so by His Lordship Honorable Justice of Kolkata High Court, Mr. Vishwanath Somadar.
So what you are saying in cases falling under clause
The
B,
rule is quoted. The rule is quoted.
yes, clause B is the period.
Clause B says, if otherwise such portion of pay and allowance as the disciplinary authority made him pay. I come under A because I am honorably acquitted. The order of reinstatement will make everything clear.
What is the meaning of if otherwise?
If otherwise means, suppose not,
There
kindly
is a
take the rule.
disciplinary proceeding pending. again.
Kindly take the rule. Kindly take the rule. Kindly take the rule. Kindly allow me to place it for Rule 13. When the suspension of a teacher is held to have been unjustifiable or not wholly justifiable, or when a teacher who has been dismissed, removed, or suspended is reinstated, in my case, the disciplinary or appellate authority may grant to him for the period of his absence from duty, A, if he is honorably acquitted, the full pay to which he would have been entitled if he had not been dismissed, removed, or suspended.
Honorable acquittal has not been defined under the rules.
No. But your lordship by
Honorable
judicial,
acquittal,
your lordship by judicial pronouncement has blood classified blood. Perhaps Captain Paul M.
not
Anthony
clear
will.
whether it will come under A or not. That you cannot.
Kindly see the order. Kindly see the order of reinstatement.
Now suppose take the other side of the story. Suppose it is not honorable acquittal. They forget about honorable acquittal. I, being the employer, I have, for my own reasons, withdrawn the dismissal order. In such a case, what happens?
Then also, my lord, I'll get the benefit. Kindly read, my lord, A conjointly with B.
Yes.
Removed, I'm just reading, my lord, A, continuing reading. Removed, suspended by any order of separately recorded or any other allowance to which he is received prior dismissal. B, if otherwise, such proportion of pay and allowance as the disciplinary appellate authority may deem fit. In a case falling under A, the period of absence from duty shall be treated as a period spent on duty. In a case falling under B, the period may be treated as on duty or leave, but it shall not be treated unless the disciplinary authority directs accordingly. For B, there has to be a decision. For A, it is automatic. In my humble understanding, Lord. Here, kindly take a situation. You dismiss me, you yourself withdraw the order. And the order of withdrawal says, I am withdrawing because you have been acquitted.
It shall not be treated.
And last line, the period of absence shall where it is neither treated as on duty nor leave be treated as a period spent on suspension. I was never been suspended. But kindly take the order of withdrawal for a second. Kindly take the order of reinstatement.
So the
68.
period from second limb,
Yes.
even if it comes under clause B, that it shall be treated as duty or as on duty or on leave.
Hmm.
That should be the discretion of the disciplinary
There
authority.
has to be a decision. They have not taken any decision. They have not taken any decision. They have straightaway by a one-liner rejected. I have never been suspended. Never been suspended. But
13, the language of rule 13
yes,
starts with when the suspension of a teacher is held. That is when the suspension of a teacher.
no, then kindly continue. Then kindly continue. Unjustified or not wholly, or when a teacher is dismissed. Second line, full 13.
Dismissed, removed, or suspended.
It covers both. Lord, kindly consider the order of reinstatement. That's the key. Lord, the order of reinstatement is the key. Order of reinstatement is the key, my lord. I repeat this. Kindly.
One thing, just my lord.
Come to
My lord.
Now kindly come to the order impugned in the writ petition,
But-
page 84, na?
Lord, may I just show the order of reinstatement? Lord,
Yes, show it.
kindly, my page 68. Kindly take this.
Page?
68. Kindly 68. Kindly allow me to place it. My lord, kindly got it, my lord?
Yes.
Whereas from the office records that Sri Swanso, head teacher of Swanso school, has been dismissed from service by order dated 30th May 2007. Whereas it also appears Sri Bose was absent in the school for a long time without informing the authority from 12 June 2006 to till date. And whereas it also appears from the office record that VEHC committee lodged a complaint regarding the misappropriation of fund of ACR before the Memory Police Station wide Memory PS case number Swanso under section Swanso, on the basis of which a case has been started. Case was started in the first special court Badwan being case number Swanso. And whereas it also appears that learned special judge first special court Badwan by its judgment dated 8th October 2012 declared that Sri Swanso is found not guilty of the offence under 409 IPC, and accordingly he is acquitted under 235(1) of CRPC. Now, considering all the entire matter, along with relevant judgment of the special court at Bardhaman, Sri Swanso has been instructed to resume his duties in the school with immediate effect. The discharge order as communicated to Sri Deepak Bose of Swanso School wide office order dated 30th May 2007 is hereby withdrawn. So the order of
30th May is page
page 67, page 67. So the order of dismissal is withdrawn in its entirety.
30th May is
2007, page, just the page before, page 67. I'm Lord, your lordship wanted me to inform your lordship whether
জন্য ডিসমিস করেন সেটা ওরা এখানে যোগ করে সেটাও হ্যাঁ ডিসমিসালটাকে উল্টে করে এটার কোনো রেফারেন্স থাকে না কারণ কারণ অ্যাপিটালের সঙ্গে তো কোনো কানেকশন নেই Okay.
Lord, may I make one alternative submission for a second, Lord? Let us for the present, Lord, forget about whether it is honorable or not honorable. I was working under them. They dismissed me for my unauthorized absence. They withdrew the entire order. The order is withdrawn in its entirety. That means entire thing will go back to the order date of dismissal.
Is that right?
Clock is set right. Then for that period from 30th May till 11th February, I could not perform my duty because of that order which you have withdrawn later on your own, without any court order, on your own. So that period,
Who will know that you are fit to rejoin on that date or not?
my lord,
Your fit certificate was on 17th of July.
yes,
That date you have mechanically set that date. That when I because your initial letter for leave does not say that grant me leave for so many months.
no, it says until I recover.
So is that a becoming of a teacher? Until I recover, you may not have recovered even after withdrawal of dismissal.
No, Lord kindly appreciates. They have not withdrawn the order in its entirety. So
That
if
is,
they
you
are,
are taking advantage of that.
no, I am not kindly take visualize the
Not
situation.
advantage, Mr.
They have
Chakraborty.
taken advantage. I could not join.
How they will allow you to join? They have dismissed you.
Yes, my lord, that dismissal order since have been withdrawn in its entirety, and the dismissal happened because, my lord, I did not join. And my lord, that I would say with humility, with the issuance of the order of reinstatement, my absence has become regularized. Because you dismiss me for absence and you withdraw that order. So you accept that period.
Notionally, they will adjust you. Forget about the benefit for that period.
My lord, the period that I was
And circumstances, we will say that will not be treated. It will be regularized as a period. For that period, they will regularize the period. But as yet has to be regularized as a period spent on duty according to you.
yes,
Then you become entitled to the entire salary.
yes.
That, Mr. Chakraborty, will be a bit difficult.
My lord, from 30th
Because
May,
it is state exchequer.
my lord,
Suppose today you consider, we will say that period will be notionally regularized, but don't pay the salary for that.
but from 30th May,
Eh?
from 30th May, the day I was dismissed, till the joining, that I am entitled to pay, my lord.
No, you were you joined on 30th of May 2007.
That is the date of dismissal.
That
And
is the
reinstatement 11th February 13.
Ah.
So from the date of dismissal till the date of reinstatement, I am entitled to salary.
You did not join at that time.
Lord, how could I join if you dismiss me?
Dismissed after 2 months.
Lord, is it the case of the respondents that they allowed me to join? I did not join despite that.
They did not issue you suspension.
Yes,
Once they do not issue you suspension, you are free to join.
my lord, I was free to join. So what is the best case that could be made against me, that I was unauthorizedly absent? I was absent.
They issued the charge sheet on
Yes,
30th of May 2007.
my lord.
It continued till the withdrawal of the charge sheet, till dropping of the proceedings and reinstatement.
No, it merged with the order of dismissal.
We understand your legal argument, Mr. Chokri, that once reinstatement, there will be no order debarring me, there will be nothing in
The date of dismissal. That is the date of dismissal. 30th May 2007 is the date of dismissal.
sheet was of
Charge sheet was of September 2006.
so September 2006. Charge sheet was issued on 30th May 2007. Charge sheet was issued.
4th September 2006 is the charge sheet. 4th September
Sorry.
2006
I'm sorry. 4th of September 2006
is the charge sheet.
and is the charge sheet. And you were
Dismissed on 30th May 2007.
30th May 2007.
Yes.
Dismissal. There was no order of suspension.
Yes.
So it was incumbent upon you to go and join.
Lord, for that period, they may grant me a notional benefit.
Yeah.
Your Lordship may send me for consideration.
That's what I
No,
was,
no.
my lord.
That you
willing to
agree.
sub-
No, from the date of dismissal till joining, my Lord will grant me the benefit. From 7th, May 7th,
Notional benefit.
no, from the date of dismissal till the date of joining. The 6 years, that 6 years.
That 6 years will be notional benefit. Because
Yes.
of this reason, there was no embargo upon you to
Yes.
join the service.
Lord,
You did
then
not
kindly allow me to make this submission, Lord. Lord, on 9th of June, I have
অনেকটা সাকসেস করে আছে 30/5/2007 থেকে
that period has Lord,
হ্যাঁ ও তো বললো আমি ফিট হয়ে গেছি জুলাই থেকে
17th July,
কিন্তু 17 থেকে তখন
17th July 2007.
এক্স্যাক্টলি
হ্যাঁ তার মানে 30/5-এর পর থেকেও জয়েন করার অধিকারও হারিয়ে ফেলেছে।
Yes, I had no right to join from 30th May.
এই জন্য ওইখানে ওর হিসেবে ভাগ না করে এই হিসেবে যদি ভাগ করা হয় যে 12/6 থেকে 30
What is falling from Justice Chakraborty, my Lord, up to the date of dismissal, I had a chance to join, I did not join. But from 30th May, I could not have joined because of the order of dismissal, even if I wanted to. Because of the order of dismissal, my Lord, if you have to withdraw the order of dismissal after 6 years, then why did you use and who will return me back these 6 years?
The period from 4th of September 2006 when the charge sheet was issued and the date of dismissal was 30th of May 2007.
That way.
You could not have joined after 30th May 2007.
Yes. And for that period also, I'll make submissions, my Lord, for that period. I'll make submissions. But my Lord, let me clear the other portion. Lord, kindly visualize the situation. Lord, kindly visualize the situation. 9th June, I write that from 12th June, I will not be able to come.
We heard you. Yes, what do you say?
Yes, only one thing.
On
But my
reply.
lord, that from the order of a charge sheet at page 50 and till that dismissal order, it
Yes.
is nearly, my lord, 1 year. That is, my lord has already, my lord, observed that part there was not embargo. That part he could have, my lord, joined. That is the thing. And the order of withdrawing the
No,
dismissal.
that portion, he was fit in.
Yes.
That comes within that because he according to him, he became fit
Yes.
on 17th of July 2007.
Yes. And the order of dismissal is apparent.
Prior to that.
Yes, but order of dismissal and that authority has automatically has not accepted that all this leave. That is why, my lord, this
What is the order of rejection of leave?
Mr. Chakraborty.
is automatically they have not accepted that they have accepted it
Mr.
as a
Let us understand.
unauthorized absence.
From
They have treated it as an unauthorized absence. That is
which
why
period?
from that 6 to 7, that part from charts, even from the
Yes,
chart sheet
6
part.
to 7.
Yes,
He became fit in July 2007
yes.
and he went to join. But at that time, he was a dismissed employee. How could he have joined?
And another thing also,
No,
my
no,
lord.
let us understand.
Yes,
So then from 12th June to he became till the date of dismissal.
till the
That is
dismissal.
from 12th of June 2006
Yes,
till 30th of May 2007.
my lord.
This period you will consider whether you will grant him leave or not. That is one thing.
That is one.
But after you have dismissed and you have withdrawn the dismissal order,
In
then
30.
he becomes, that period has to be spent on duty. That is his argument. What is your argument to that issue? You tell us.
That part, my lord, since I would have, my lord, this easier since the DPSC, if they had appeared, my lord, hopefully, my lord, they have
You are
not been
the
even
SI
served.
you are the ex officio secretary of
Yes, sir.
DPS.
DI will be the ex officio secretary. But here, that part, my lord, kindly send it and relegate to consider that for that period.
No,
From
no,
dismissal to withdrawal of
What is your defense to this? From the date of dismissal till the date of withdrawal of such
Yes,
dismissal.
I understood, my lord.
He is not to be blamed for that because you have dismissed, you have again merrily withdrawn. Now, to that period, what we were thinking, subject to what we are thinking is from 30th May 2000.
30th May 7. Yes.
Till April 2030. Date of
What is
reinstatement.
your contention?
May I
That
just
you
put
have
once for the with the DI regarding this period from the
you tell us you have been started disbursement of salary from when?
From
Please
the
say.
month of May 2013,
May 2030.
because actually I joined on 30th April.
yes from page 84.
No, February the order is passed. Thereafter, my writ petition challenging the order of dismissal was pending. They said you go withdraw, then come back. That period took 2 months' time. Then I joined, my lord, from
Withdraw what?
May 2030.
Lord, I filed a writ petition challenging the order of dismissal. That was
That
kept,
you withdraw.
that you withdrew because the order of dismissal is
That
recalled.
is page
Page 72. Kindly have a look at that order.
72.
72.
19 points, 21 months.
It is submitted by Mr. Mahata. It is submitted by Mr. Mahata on instruction that his client does not want to proceed with the instant writ petition as relief sought for has been granted by the office by memo dated 11th February 2013, whereas the impugned memo 30th May 2007 has been withdrawn and the petitioner has been instructed to resume his duties forthwith, and as a consequently, the petitioner by a letter dated 6 March 2013 has requested him to withdraw the writ petition. It is submitted that pursuant to the office memorandum 11th February 13, the petitioner has rejoined. Let the copy of the office memorandum 11th February 13 and later 6 March 13 file be kept on record. With this view, office memorandum so and so is dismissed as with. And page 78, I rejoined. My lords are looking at my lord page. Obviously, I am getting salary from the month of May. Lord, I am getting salary from May 2013.
ওরা ভুলভাল তো এখানটা ঢুকিয়ে ফেলি এই যে
99.
tendency
Include order in the writ petition.
oh sorry and the applicant was a
84, 84.
ওরা তো বলে দিয়েছে 335 ছিল হ্যাঁ তার জন্যই ওরা পরবর্তী ক্ষেত্রে দুই এক হাজার পায় এটা তো ফ্রি Internal duty
Spent on duty, yes, yes. আমাকে চার্জশিট দেয়নি, অন্য অ্যাড্রেসে পাঠিয়েছে, সেটাই বলবো আমি। Lord,
We have the learned advocates.
we are keeping it for orders. And if you to do what you want.
two things only. Lord, kindly take page 84. Lord, I am sure your lordships Lord have got the correct dates. What I am praying today, I want to make it very clear. Kindly come to page 84.
Yes.
Kindly see the Alias Chatterjee also kindly take me Lord page 84. I'm so sorry, Lord. Yes. Lord, kindly see what they have rejected from 1st July 2006 till 30th April 2013. My lords are at page 84, my lord.
Why 1st July they are taking?
I don't know. It should be, my lord, from June only.
No, it will be 18th of July, na?
No. From 12 June, I sought for leave. They paid me salary for the month of June 2006.
From 12th June 2006 till
From 12th June 2006 till 29 or 30th May 2007, I was on, I applied for leave. Let us take it this way. Because the application was never rejected. From 30th May 2007 till
they will consider the period from 12th June till 30th May.
30th May, they will
They
consider.
will regularize.
How they will regularize? This is one.
Done full pay or half pay or
Yes. From 30th May, that is from 30th May 2007 till 30th April 2013. Because although the order of reinstatement passed on 11th
give the actual date.
Yes.
30th May 2007 till 11th of February 2013.
that is the order of reinstatement, but I was actually allowed to join on 30th April.
Oh, joined on 30th April.
I joined on 2nd May, 30th April, the order came. Page ta bole de ekটু. Not page 77, if I am not wrong. Just allow me to. Page 77. তাই তো রে, দেখ তো।
Your prayer will be for period spent on duty, but you will be
or once my lord noting the date, once my lord page 51 আছে না, আমি তোমার against
না না, against
that was also a charge that from 12th of June 2006 till date he was my lord
charge was 1st July 2006. Page 84.
yes, no, page 51 once
এটা
my
কি?
lord, come
আমার
to
এটা
page
কি?
51 once
এটা কি?
the charges
12 June
yes
2006 and onward.
and onwards. That is also a date my lord.
You in your page 84 letter,
এটা
while
Yes,
withdrawing the same,
Page 17 my
mentioned
letter.
it as first
Yes, that is
77.
the date my lord, I'm also unable to
from 12th June.
June 2006
Yes.
কি বলছিস বুঝতে পারছি।
এই চার্জের এটাতে আছে কিনা তোমার অ্যাবসেন্টার স্টার্টিং ফ্রম 12 জুন
Yes, because I stopped going to school from 12th June 2006. There is no dispute. 9th June I applied that from 12th I cannot go for my ill health. But what I'm trying to tell your lordship is, although the order of reinstatement came on 11th February, kindly now take page 77 for a second. On 25th April 2013, they could allow me a school. Because where I was working, actually, that school, there was no vacancy because in the 6 years, the vacancy was filled up. The school from where I was dismissed, a school from where I was dismissed, the vacancy got filled up in the last 6 years. Then page 77, kindly take.
You actually joined on 30th April.
Actually joined on 2nd May. So till 30th April, because I got the salary for the month of May. So till 30th April, I should get salary, because that period I could not perform my duty because of the order of dismissal. That is what they have rejected at page 84. That it will be without pay. It cannot be without pay. I have to be treated on duty. But kindly visualize a situation that the writ petition that I filed, that was allowed. In the order, I would have got that the entire thing is set aside and I'll be treated from duty from the date of dismissal. Since you withdraw it, I have to be treated on
You are
duty.
reaping the benefits of the council letter.
Lord, they have done it, Lord. Lord,
That is why you are so strong.
Lord, I was deprived for their letter on.
Decided. You know, and that is clearly. Decision has been. That means order of punishment. Has been. Order of punishment is nothing but a declaration that this period he was. তাহলে সেই ডিসিশনটা ইয়ে হয়ে গেছে, তো প্রসিডিংটা আমাদের কোথায় আবার ইনিশিয়েট করতে হবে সেটা নয়। এবারে অ্যাবসেন্সটা করছে, অ্যাকচুয়ালি অ্যাবসেন্সটা ওরা কি হিসাবে ট্রিট করতে তোমার কথা লিভ দিই বা কোন লিভটা মেডিকেল লিভ দেবে কি দেবে সেটা তোরা ঠিক। এই পিরিয়ডটা যেহেতু অ্যাকুইটালটা খেয়ে দিল স্পেন্ড অন ডিউটি।
তুই যেটা বলছিস ওইটা দেখতে গেলে আমার ওই পিরিয়ডটা পাওয়া উচিত, কারণ তুমি আমায় অ্যাবসেন্ট বলে ডিসমিস করে আবার নিয়ে নিচ্ছ, তোমার তো রেগুলারাইজ করে
ওটা ওয়েব করে দিচ্ছি না কেন?
because the moment you reinstate you waive the allegation.
That should be expressly allowing you to be on leave.
সেটা নিতে হবে, আবার ফেরত পাঠাবে, রিজেক্ট তো করছে না।
The learned advocates appearing for the respective parties have concluded their arguments. Is the matter as for orders in the daily supplementary list of this court on মঙ্গলবার না? 5th তারিখে 5 তারিখ on 5th as fixed at 1 p.m.
But DPSC is
Pass
not
order.
appearing.
Eh?
Okay, DPSC,
Eh,
they are not appearing.
কি করা যাবে?
That cannot be done. What?
Not only
DPSC, you are representing DPSC.
বাবা
No, no.
Forwarders না করে ওটা forwarders বললে আবার নতুন হেডিং এ
সিএভি
হ্যাঁ অর্ডারটা পাস করে দেবো।
But only one, if I may allow to say this, one food for thought, not when your lordship not consider it. Lord, allegation was that I was absent, charge sheet issued, dismissal, withdrawn. By withdrawing the entire dismissal, you also withdraw the allegation. You accept
That part,
that, and my leave application was never rejected.
but I am objecting that.
That is the issue.
What's-
When I withdraw the dismissal order,
Yes.
are you given a totally clean sheet?
Hello.
Legally speaking, but problem is
That
show us
part-
a judgment on that
Yes, my lord,
point.
I shall. But, that part, Mr. Chakraborty
Entire
was
thing
suggesting
goes.
that
Everything goes.
The judgment reads that suppose you are dismissed, if it were substituted a punishment, suppose dismissal to say droppage of
Here, lowering punishment.
What?
Here, it is not the case.
loss of
Here,
increment.
you withdraw the proceeding.
let us see. We
But
will
in the
pass.
paper, there is no proceeding at all.
dismissal
এটা নাও তো।
as in criminal matter,
ওর ভেতর
হ্যাঁ।
দিকে আমার বলে দেবে।
one accused is convicted, that is another,
Yes,
and another is punishment.
yes.
An order of sentence is stayed, yet the order of conviction will stand.
Yes,
That means decision that you are guilty, that is now whether you will be dismissed or removed or any pay will be reduction, it is punishment.
That is for the disciplinary authority to impose. But the inquiring officer, he will find whether I'm guilty or not in the service jurisprudence. Here, the entire proceeding is withdrawn. But I will go back happily for the period from June to July 7. But kindly grant me the benefit of the period of dismissal. I should be treated as on duty and get the benefit of payment.
One
That's my
just,
submission.
one submission, my lord, that dismissal is already, but that automatically has not waived. The DPSC has not waived the period.
Charge sheet goes na.
Just it goes.
That's it. Got
তাহলে
dismissal.
কি
Withdraw the proceed. You are dropped.
That is all right. That is dismissal gone.
না,
But
charge
that
sheet
cannot be treated as
So for
that
that,
unauthorized leave they have waived.
so that ought to have been your defense. You
Yes.
could have continued with the proceeding that we
Yes.
are dismissal order, we will not
হ্যাঁ।
pass. You will substitute the
অন্য
punishment.
কিছু করবো।
Yes, that part is
Once you
silent.
substitute that
Yes.
period spent on
Substitution is
duty
also-
amount,
Yes.
that will be automatically adjusted. You could have got the
Yes,
benefit.
that
Lowering
part
on
is-
rank, lowering on increment,
But
many things
it's-
could have
that
been
is
done.
the problem.
Show us any judgment. We are
Let me
keeping it
try.
as for
Lord,
orders.
today I'm on a clean slate. There's
You are
nothing
not on a
else.
clean set, Mr. Chakraborty. Yes, next.
Grateful to lordship.
I am appearing for the, can it be taken day after tomorrow? I am appearing for the India.
Sorry.
Update by Mr. DN Raibabu.
Yes, place your case.
I am praying leave to file a video.
একটু আমাকে দিয়ে দিন। তুলে দিতে পারি? সেটা সাপোজ আমরা আজকে প্রসিড করি কোনটাতে
Number three, there's a difference here. Three, তুমি চাইছো কি আমি বলছি কেন চাকরি যখন যেটা তুমি for early hearing, listing for early hearing.
Huh?
I convey my gratitude.
Yes.
Huh.
What is your case?
I have retired from Calcutta Telephones, BSNL, in the year 2012
Just
in class 3 post. And at the time of retirement, I was not given any pension benefits. After 70 days,
when did you retire?
I have retired in 30th November 2012.
30th November
November 2012.
12. Yes.
I was not given any
No pensionary benefit given.
After 70 days, 17, I was intimated that your pension given 20 years ago has been cancelled because their own fault.
But you retired on 30th of November 2012.
Yeah.
You were not being paid the pensionary benefits. Then what happened?
After 70 days, and order issued on 5/3/2013. 5/2/2013. I think annexer 110 to 11.
10 to 11. Yes.
Last order in the when I submit second times original application before the tribunal and pass an order dated 25th January 2019, 34 to 34, page number 34.
So challenging that order of 5th February.
Order of the time.
Challenging the order of the 5th February 2013, you preferred way.
Oh, first way.
What happened in that?
That was in 2016. 2016, the order passed to reconsider. To call the petitioner in the telephone phone and consider the case and submit all the money recovered from him. But then,
when was that order passed?
Order passed. I am saying that 25th February 2016, 16 page number 132 to 133. Annexer running page number 132 to 133.
Yes.
And direction was given to settle the matter within 3 months.
Then what happened?
They delayed and at last called me with post facto letter. Again I prayed, post facto letter. Again I prayed. Then he called me and he said, I will consider. Then I will consider you.
When was the order passed? Ultimately?
Order passed 8 to 17. 8 to 17, page number 140.
Date of the order.
Date 8 February 2017.
All right. This is at page?
Running page number 140 to 141.
140 to 140. They rejected.
Call me. At last I give a submission, written submission. I give submission and praying two conditions. That
No. That order you challenged before the tribunal.
Before the challenge.
This 8th of February 2017 order was challenged before the tribunal.
Second time.
Very good. Now first show us the July 19th, 2019 was the first. You preferred approach the High Court.
I don't know. I couldn't tribunal. Honorable tribunal.
Tribunal passed the final order when?
16.
25th January 2019.
20 February 2016. Page number 132 to 133.
That was the first order
First order.
by which you were relegated for consideration.
Consideration.
Now, final order was passed by them on 8th of February 2017.
The tribunal, next tribunal order, 25th January 2019. Second time,
5th January,
5th January 2019.
page,
34 to 40.
page
34 to 40. 34 to 40.
This is the order impugned here.
This is order, my lord.
Now, why did you, against this order, you preferred earlier another WPCT?
First challenge against the tribunal order?
Page 157, kindly come. Come to page 157.
157. One have first.
আবার বলে first, let us understand 25th January 2019 was the tribunal's order.
First,
Aggrieved by that, you preferred a writ petition.
no, writ petition at first. First, I am in the economic hardship. My lord, I first think that whatever amount I am receiving, I first receive to save my family. But a drowning man, nothing but to catch the straw. That is why I came WPCT 50. 50.
All right.
But Honorable Justice.
Wait.
I was giving liberty.
After the dismissal of their writ petition at page 157, then what happened?
I come to court to the judge so that I may receive the amount direction to deposit the amount. Direction to post direction. Honorable Justice Dipankar Das Datto directed them to deposit all the things as per direction of the Honorable Tribunal.
Very good. They have not done so.
They deposited the amount, and next working day withdraw the amount. We withdraw the amount and re-deposited next day. Kindly page number. Come.
Page number.
Coming. Passbook, my passbook, 160 to 161. 160 to 161. Kindly 161. Kindly come to 161. That's 165.
Yes.
Coming. First to 60. Kindly see at below 7,97,789 deposited, credited. Next working date.
That was on 17th August.
That was 17th August. Grateful.
High Court disposed of the matter on 19th July.
19th July.
They deposited on 17th August.
17th August.
Then what happened? They withdrew.
They deposited only the minimum amount that due to cancellation of my promotions, my pay was reduced to minimum. And on that minimum pay calculated, this amount was deposited in the bank. minimum amount deposited into the bank, and next date withdraw on
No, High Court directed them
to
to
deposit as directed by the tribunal.
4,85,000.
7,97,000, 7 lakh
Where is that 7,97,000?
Then withdraw the amount next page.
Kindly come to page
Page number
157.
161.
Please come to 157 first.
157. Directed to deposit the amount.
What amount? Deposit the amount of 4,85,294.
4 lakh.
Very good. You got it? So they said that this amount has to be was recovered from your benefit. Recovered. So court directed that you cannot recover, you have to deposit the amount. That was the court's direction. Their writ petition was dismissed. Now, after that, what happened? Did they deposit that 4,85,000?
No, 7,97,000.
So that is much above 4,85,000.
My prayer is that due to cancellation of my promotion, a large number of increments.
Was that the subject matter in the original application? Original application which was disposed of on 25 January 2019.
Original second application, original application. Sorry, applications and partially goes in favor of me, but maximum in against of me. That is why I come to before the Honorable High Court to dismiss the order 5/2/2013 and 8/2/2017, and other. Also, I am also directed to deposit the amounts from the house. I have deposited 73,974 taken from the house. Kindly see page number. I am coming. LPC 1,112 to 115. I had to deposit this amount as per their direction. They realize
how can you prefer a writ petition for that? You have to go back to the tribunal then.
It is my fault. I did not know that at that time. I don't know. All things made myself.
You knew. That is why the court kept the maintainability point open. Why did you unnecessarily proceed to the High Court?
Now, Honorable Justice accepted the case. Well, you may clear anywhere, either High Court or tribunal.
No.
Because it is already.
What you are challenging before us, tell us. Your first order of the 5th of February 2013 order, page 110.
Kindly see my affidavit of opposition one. There it. Direction to page 51.
Yes, what you are arguing?
My lord, kindly see my affidavit of opposition last page.
Last page
51. 51. Contempt application filed against that order. Last paragraph only. We make it clear that this order shall not preclude the petitioner to pursue this remedy before the appropriate forum. That is cat.
No, what remedy he wanted?
That is a refund we have already returned. If fluctuate, my lord, he is wanting more money.
No. On what basis?
We have pursuant to order passed by this honorable court, my lord. We have refunded, but he asking more money because of their own calculation.
That is not. I want for
And that is
cancellation
a
of the
separate-
original order.
That is a new cause of
I have lost a number of increments, and now I am getting more than 1 lakh less amount per year.
Have you been paid this amount of 4,85,000?
Yes, I received. Now I am.
Now you are challenging which order? Tell us.
5/2/13.
5/2/2013.
And 8/2/2017, same order.
5/2/2013 and 8/2/2017. Achha, show us that order.
That already.
5/2.
5/2/2013 order, you already challenged before the tribunal.
Tribunal.
Tribunal said, kindly come to the order of the tribunal, page 100 and page 132.
132, 33.
What did the tribunal
Tribunal
say?
did not cancel this, my prayer.
So let us see what happens.
That was good order.
To the benefit of Mr. Ali, by an order dated 5th February 2013,
13.
they recovered money from you.
Yes.
Challenging that, you went to the tribunal. Tribunal said that so far as the amount which has been recovered from your gratuity, you have to deposit that. And the remaining amount, you should be given an opportunity of hearing. Right?
No, tribunal did not order me.
Yes. Tribunal's order, kindly come to page
Before
1.
by going to the tribunal,
Yeah.
they realized from me on compulsion.
Right. Now, what did the tribunal ultimately direct? Kindly come to page 133.
133. Deposit all him direction to the rest.
Let's answer our query first. Let us understand. Tribunal said that whatever money has been collected from you, that with interest they will keep it in a bank. And the matter was directed
For revision of pension.
Hmm.
Okay, revision of pension. The subsequent pension has been
Pension is
revised,
more than 1 lakh
reduced.
reduced per year. Main thing, I am obliged.
Now, nowhere the decision that the BCR in 1993 was erroneously given to it. That decision stands.
There is so much argument.
That is not under challenge.
That is, I was given promotion in the first I have appeared in 1987.
We cannot decide that.
Decide no.
Today, what order has attained finality?
Finally, I didn't.
What order has attained finality? The order of 25th January 2018 passed by the tribunal.
Tribunal had to consider the all cases.
No.
to consider.
25th January 2019, kindly come
29, no, 17,
2019.
19.
That is the last order passed by the tribunal.
But,
Paragraph 7, page 40.
but
What has been decided?
against, I have come against this thing.
Arey, how can you come against this? This order is in your favor. That is why they preferred the writ petition.
40. 40, man.
এরা ফাইল করেছে না না এইটা করেছে এই অর্ডারটাকে চ্যালেঞ্জ করে ওরা প্রথমে হাইকোর্টে got it now Mr. Sur after this order was challenged by them court directed that no you cannot recover you have to pay that amount of 4 lakhs rupees etc whatever as they did not pay you preferred a contempt application. Now, after contempt, that amount was paid to you. Now, how can you challenge the order of 5th of February 2013 before us, pertaining to the actual pensionary benefits which you are entitled to allegedly? That we cannot consider in this application. We cannot.
Actually, I challenge 5 to 13 is first set aside. Set aside the order. That was not spoken here.
Where it was set aside, kindly set aside and send back for consideration. That is set aside and send back for consideration. Yes or no? Yes or no?
Yes.
So you are an advocate.
Now,
After the
after
issue,
retirement, I am practicing.
so very good. After retirement, when you are practicing, today you are saying that I am agreed by the earlier order of 5th February 2013
And next order also.
and 8th of February 2017.
17.
This issue, how we can decide? We cannot decide. If you are aggrieved, you have to take appropriate steps before the tribunal.
Thank you.
Yes, Mr.
You
Gupta.
would be barred by the constructive based judicature.
Pardon?
You would be barred by constructive based judicature. That point ought to have been raised at the time of placing your original application before that. You have not raised this point. Then you took the point, I have written, whatever may be the cause of such recovery, you stop. Since master servant relation has ceased. Sambabu Dharma. Then court accepted your plea and said, yes, retract, no relation, don't deduct. Pay the money.
My lord, High Court has enormous
At that
power
time, you have not
to set
stated.
aside this order. High Court has enormous power to set aside this order. Why you have not spoken about the
We have power, but the issue has rested. It cannot be reopened by us. Then at least at the time when the matter was heard by the division bench which rejected their matter,
Yes, sir.
you should have told the division bench that keep this point open so that I can go and challenge. And in fact, court allowed you. Court kept the in the contempt petition, court said that you would be at remedy to avail appropriate remedies if at all you are entitled to.
now, is it possible to go again? Tribunal? I can.
If we aggrieved by that,
Even if you cannot go back to the
You
tribunal,
give us any way out how we can
send you back.
go back and test the veracity of
More
the
than
order.
1 lakh, I am getting less.
Uh-huh.
I am getting more than 1 lakh per year in the pension. Less amount.
No, you have been paid that 4,85,000 recovered amount has been paid to you.
That was calculated on the reduced pay.
Very good.
Reduced pay.
But that promotion, Mr. Ali, promotion is a matter which ought to have been considered before the tribunal. So where is your affidavit? Let the affidavits exchanged by the parties be kept on record. Mr. Ali, the petitioner appearing in person, and Mr. Gupta, learned advocate appearing for the respondents, have concluded their arguments. List the matter as for orders on পরের দিনটা দিয়ে দাও কবে ওটা করে 6 তারিখ করেছো? হ্যাঁ, 5th on 7th as fixed at 1 p.m. We will pass our orders. All right. 7th we will pass the order. Today we cannot pass. 7th of this month.
March, 7th March.
We
Then
will go
kindly
through your
consider-
brief again. Let us also find out if you can get any benefit or not.
Thank you. I am in severe hardship.
You also think how you can ask us to give you further benefit. All right.
7th time.
1 o'clock, we'll pass the order. Mr. Gupta,
Yes, my lord.
we will pass order against you. Not against your clients, but against you.
That I have already told him, go before the cat. Earlier, when
He doesn't listen, nah? He doesn't listen.
no, their lordship also said verbally that go to the cat again. Their lordships. But in spite of that, again filing writ petition.
Oh,
In spite of going there.
you are now an advocate, nah?
Now advocate, but without brief. Without brief. Only one.
Please think, if you are inviting us to pass an order, then if we dismiss your application, you will have no opportunity to go anywhere else. But if you decide that, okay, I cannot get this benefit here, I will go back to the tribunal, we can dismiss your petition on your submission, but we cannot force you. Think over this issue. Understood? Recording your submission,
Yes, yes, yes.
understood? Recording your submission, we will leave you to avail the benefit before the tribunal if at all you are entitled to. এটাও করতে পারবো।
Yes.
Think. Yes. Next.
You
call.
read.
Any judgment come with.
Now there is no recovery, now reduction of pension amount.
This phase চলে গেছে। বললো এই recover কে বলে।
না, নিশ্চয়ই এখানটা দিয়েছি আগে যে কাজ করে থাকে লাস্ট অর্ডারটা।
দেখে নাও।
কাজ করে থাকে তাই বলবো।
Yes.
But there are two analogous matters,
Which one?
4 and 5.
Matter I am appearing virtually, my lord. On behalf
Yes. 4 and 5. Yes.
Item number 5, I am appearing for the petitioner. My lord, item number 4, I am for the petition.
I am appearing for respond number, my lord, in 4 and 5.
Yes. What is the issue?
The issue, my lord, cancellation of the promotion.
Cancellation of your promotion.
Enter
And
selection,
we are
enter
today, my
cancel.
lord, today possibly, my lord, the CAN application came up for hearing for addition of party. And the, my lord, the main application, my lord, this is my lord, big matter, my lord. So another date may kindly be fixed for my lord, final hearing, my lord. Because CAN, my lord, my learned friend Borun Chatterjee has filed, my lord, for addition of party, possibly, my lord. He has mentioned.
For addition of party, you have the similarly circumstances. We have not approached before the High Court. We are in the I am in the same panel. That's why I filed an application for addition of party as a petitioner. CAN 1 or 2 or 2020. I have already served
You are appearing in Partho Chatterjee.
in WVCT.
You were a party in the tribunal. No?
Yes, no, they did CAN. I am not the party.
Mm.
I am in the panel.
Where you are party?
No, when I am not party.
No.
Addition of party, no.
You are opposing such prayer.
Similarly,
Since my lord, party to the proceedings, my lord. So
Are
it's
we-
difficult, my lord,
Tell us whether you are opposing such prayer or not.
we are opposing.
let me find it. We're in the same panel. I've been working for the post of 5 years. Thereafter, that I have not filed any application before that.
Fact of the case is this.
Fact, we are not concerned, Mr. Devnath. We are wanting to regularize the applications first. Very good. You have not used any opposition.
Today, first time appearing in this matter, my lord. This matter is appearing first time, can application. If you is direct, my lord, we will file, my lord.
These were not pointed out to us, upgraded.
Because my matter was mentioned by me, but copy
You
was
did
not.
not tell us, na, these applications. have been-
Application I have mentioned, my lord. In
They have,
application
they
I have
have.
mentioned.
They have,
On application also.
and they have not also given a copy to me also.
এটা কি তাহলে
But the main matter, my lord, lordships may, my lord, fixed any day, my lord. We are, my lord, ready with the matter, my lord. Any day, my lord.
Decide, my lord, my on that date, my lord, decide the can application. Let the main matter be hard. Little urgency is there, my lord. Somebody will be retired in the meantime.
Madam, there is some
what
question
do
of
you want us to do?
How party, if to intervene or anything like that.
বুধবার করে নেবেন।
Next week is given.
Next Wednesday. Next Wednesday. Because we are
Very
suffering
clear.
since
Why,
19.
what are the two applications? Why you want to add yourself? If the
the-
petition goes in your
All
favor,
right, all right. Matter may be tag with the main matter may be hard or application may be on that date, my lord, decide. If the matter is goes in my favor, I will automatically I will be benefited. Because I
Yes.
am in the same panel.
then you withdraw the application.
Right.
How many applications?
One, only one.
Huh?
one.
Only one application, that is can one.
Can 2 of 2024. Shomir Kumar Mondal.
Very good. Then argue on merit. Yes.
The petitioners,
My lord, today, my lord, for the final hearing,
Intervenor application
বললাম ছিল না?
ওরা রাত টানতে পারবে না।
ও যদি বেনিফিটটা পায় অটোমেটিক্যালি তো সবাই benefit পাবে।
my lord, for final hearing, the lordships may kindly, my lord, fix another day, my lord.
Why,
For
Mr.
final hearing.
We are prefer
They have, my lord, mentioned the matter for
matter,
addition of party.
addition of party
They
we
have
will
sub notice that they will, my lord,
start.
My lord,
and now, my lord,
Paper book is there.
AG also appearing in this matter, my lord. So, another date, any day, my lord,
my lord just Deepangar
tomorrow or any day.
order
He will
without
not
without
take
granting the stay.
application for addition of party.
His lordship directed, their lordship directed matter to be hard expeditiously. So that is the reason, no direction paper book is given to us.
We, Mr. Ghosh, then we allow the application for addition on consent and fix the
That
matter.
is kept 20
We-
along with your main matter, that can be made. Any day, my lord, we are ready, my lord, any day kindly fix, my lord.
Come on the next date. Next date.
Start to করলো। Then my lord,
You take instruction, you withdraw, we will hear it
I
finally.
will tell my lord, that's the application.
then my lord, next Wednesday. Next Wednesday. Not
Next
today.
Wednesday, first matter.
First matter, all right.
Very good.
Done.
Some order will
Yes?
order first for
Oh, this will be the second matter. First we have
Very
fixed.
good. No problem, no problem.
এই যে দাও।
Lordship pass an order today.
ও কি order pass করছে?
For our benefit, my lord.
Hard the rather than this the matter for further consideration or even মানে 6 তারিখ 6 March.
My lord, before my lord rises, my lord will be taking up this matters on, my item is item number 6. My lord will be taking up on next Wednesday.
You will come to know when we come back.
So
আমি 5 এ আছি 5 ও 4 এ আমি 136 এ আছি অজয় দেবনাথ
কোটা বিচার এই ভদ্র আপনি কোটা বিচার তো আপনি
দাদা পাওয়ারটা এখানে দেবো
একটা ম্যাট পিটিশন ফাইল
পাওয়ারটা এখানে দেবো একটা নো অবজেকশন পাওয়ার আছে ডিপার্টমেন্টে
ম্যাট 204
তারিখে ডেট ছিল, আসেনি। আমি সোমবার মেনশন করলাম 26 তারিখেতে, আর সাহেব বললেন যে আর্জেন্সি লিখে দিয়ে দাও। দিয়েছিলাম, ওটার কোনো ফিউচার জানেন? ছেলেটা মানে মারা পড়ে যাবে আর কি। সিঙ্গেল বেঞ্চে অর্ডার হয়েছে,
কবে হবে বসে চলো আমার কি আছে দেখো
calculated, there are total 36 appeals before the court.
36
The total number of appellants we have calculated, it is coming to 569. Now there are certain CAN applications also.
We filed the CAN application. CAN
we
application.
have also filed CAN application and some of the CAN application already added in pursuance of the earlier court order, my lord, and some are not yet added.
Yes, so what I was
But our
submitting is,
CAN application is listed today.
no, the new CAN applications I will address later. Those who have come up later after hearing what had fallen from the court on the last occasion, kindly do not take account of those litigants. But the litigants who were here from the beginning. So primarily the appellants. The appellants, they are 569.
The applicants or the added applicants.
And if we go by the added candidates, as far as we could ascertain, we have managed to ascertain 494. Now, whether all CAN applications have been properly served upon the commission, that I don't know. But what has been served upon us, this is the figure.
So 569 is the appellants and the added persons till date who has been there?
No, only the appellants.
Oh, only the appellants.
Yes.
And then how many added persons are there?
Already added.
We have managed to detect 494.
All right. And some are in the pipeline.
In the pipeline, meaning I would call them fence sitters. After it fell from the court on the last occasion, that your lordships would consider whether we could keep aside the vacancies. Then they started filing these CAN applications, these application for addition. And
so which are those new applications?
There are 9 new applications. The total candidates are another 352. Now the total vacancies, even if we look at the figures which we have, and it might appear that quite a large number of candidates are before the court, but the total number of final vacancies is 14,339. So even if we, that is the final vacancy as was declared. Now, if we keep aside the vacancies for the litigants, even all of them, still more than 10,000 or 11 or maybe more than that, they will get appointments. They will get appointments. So as had fallen from the court on the last occasion, we are making this prayer that if we are allowed to, the counseling is over. They have already selected their schools. The recommendations were not issued. That was stayed.
Of all the 4,399 vacancies?
Yes, of all the candidates who were called for the first phase of counseling, 13,000 not.
Almost complete.
Yes.
So that was pursuant to the leave board?
Yes. The court allowed the counseling, but directed us not to hand over the recommendation letter. So, but they are ready. their schools are chosen. So if the exercise is carried out, keeping aside the vacant, because again, the vacancy will also have to be against their particular category. It's not like a lump sum. So I have, say, 14,000 vacancies, but these litigants belonging to different categories. So when what I was submitting to the court, instead of going by particular figures, just understanding the percentage, approximate percentage, at the time of keeping aside the vacancies, that again the commission will definitely go through the exercise and ensure that none of the litigants are deprived. Their rights we will secure, but the others let us carry on with the recommendation and appointments.
Vacancies are under different subjects.
Yes, different subject, caste category, gender category, medium of instruction, all these things will, that chart we have. Even now I am carrying it. Not only that, I have also a chart showing how far back the litigants are. They, according to us, do not have a chance of getting in. But just to get out of the impasse, as had fallen from your lordships on the last day, we are making this prayer that let us give the appointments, keeping aside whatever number of vacancies is necessary for the litigants. But your lordships will also fix a date that after this date, no further litigant will get this benefit. Those who have come after hearing the view of the court, they are simply fence sitters.
Please for the appeal, Mr. Bhattacharya.
I am for the appellant also. His suggestion is a dangerous proposition. The entire process is tainted. Any appointment would amount to giving even if temporarily sanctioned to this tainted process. That's why the other division bench says no interim order, any further interim order, matter would be hard on merit disposed of. Interim order already. Kindly get the matter hard and disposed on merit.
Yes, start.
Yes. Since that he is the principal appellant, we'll let him start.
Your lordship will.
কেন শুনতে শুনানি তো আপত্তি করছিস কেন শুন
শুনানি কি একদিনে শেষ হবে?
না হলে চলবে 4 দিন শুনানি চলবে
The thing is, this litigation has.
Are you opposing the further applications which have been filed and served upon you?
No, I'm only suggesting that they should not be included. If your lordships direct, the number is not big.
Thing is that this was what we were considering.
Yes.
When the challenge comes that this cannot be done at all, you have to hear us. Then we have to hear them and pass appropriate orders to that effect.
Yes, but for say for 2,000 candidates, if we take the maximum,
let them begin the submission. Then we can.
For 2,000 candidates, keeping 14,000 candidates stranded. Not only just candidates, we have to think that they are teachers, schools, meaning students, education. So it is.
So Dr. Patro, that was what we were wanting to know. You have given us the classification of vacancies. Now, this has to be they would, as it fell from Mr. Bhattacharya, that the entire selection process is tainted. That is the usual submission which is made. So we have to listen to them. There is no, we cannot, we have to see their defense. Let us see, we start. Yes.
There are writ petitions, at our instance.
So far as the applications are concerned, are you opposing those? Or who are the other parties so that they can be? Anyway, Mr. Shanal, you start.
Yes, yes. Begin. Let me get it. I tell you,
to us how many there are. We are told how many writ petitions were filed.
Writ petition, appeal. How many? Appeal, I believe.
They are all appeals. All appeals.
In the first appeal, which is the leading appeal, immediately number 638.
17 to 52.
Yes.
Here your losses will find 55 writ petitions.
And then applicant added
and then your losses from time to time, additions have been made.
Total 2100.
Additions have been made to
in the appeal itself.
In different appeals.
Different. In this appeal. Leading appeal.
In this matter, all have been added. One
most
appeal.
of them on one appeal.
No, give us the figure, those applications for additions which have been allowed that are pertaining to separate
order,
appeals,
court
so
order.
only one appeal.
Only one appeal. In my appeal, they have been added.
আচ্ছা, এই order sheet টা দাও।
এই তুলনায় ব্যাকগ্রাউন্ড করলে মামলা হবে। কতগুলো add করেছে?
Yes. You show us the order. You show us the order of the order impugned before us.
Impugned before your lordship. That order, your lordships,
Index.
I have handed up to your lordships an index of rules and judgments. এটা তো পাবো তো? Index of rules and judgments. I have handed up to your lordships. Probably the coordinate bench.
So in all the appeals, who will make the lead submission? Because you will partly address, then Mr. Bhattacharya
No,
will
no,
partly
I-
address. Then again another learned. Then we can
With the
you please decide amongst you so that we will hear
whatever
the leader.
whatever the way we argued before our coordinator.
No, Mr. Sharnal, we cannot allow 40 learned advocates to argue in respect of 36 appeals.
I'm not. I get your lordship's point. I answered to your lordship's
Yes.
point. My lord, I will be arguing in all the matters. My lord, leading matter is the best, my lord.
Yes.
All the points will cover that.
So, Mr. Bhattacharya, we would also request, because there are many advocates.
He, since the main appellant, we would not repeat what he argues. If anything is left out, we
By you. Then let us, it is understood, we are hearing Mr. Bhattacharya and Mr. Sharnal.
My lord,
If anybody has to say anything.
my lord, I tell your lordship, Mr. Mikro.
Problem starts thereafter. After you complete and leave, then another battery of advocates.
followed by the other bench after Mr. Shania led by Mr. Joyanta Mitra argued. Then Lord, I took up and wanted to supplement that.
And I also made some submission supplement.
So, Mr. What supplemented, you leave it upon them and help them so that we can finish it up. Yes.
Argument is same.
But only one indulgence. A writ petition on the self same subject matter has been filed, it's pending. Would it be a lordship's pleasure to take the writ petition?
No. Let us see this one.
Very well.
We will hear and finish it up. We will not.
Very
Yes, Mr. Shandal.
My lord, your lordship wanted to first see
Show us the order.
order under appeal. My lord, this bunch of papers page, running page 102.
Justice Sen has submission was complete before his
One submission was complete.
Notes were filed.
Notes were, but my lord, I will
Notes were
make
filed at the beginning. The appellants had all concluded their submissions. School Service Commission had also virtually finished. Only one point was left to be argued. 2 points.
Yes, Mr.
My lord, page 102, order dated 9th July 2021. This writ petition has been filed by 55
Page
petition-
99, you said?
Page 102. Because your lordship kindly see the cost title Rajiv Brahmo.
Yes.
Both the earlier orders also. This writ application has been filed by 55 petitioners, but court fees have been paid in respect of one. However, learned advocate for the petitioner intimates this court that under entry number such and such, full court fees have been paid. Hereby using a supplementary affidavit, the interview list of upper primary teachers prepared by the West Bengal Central School Service Commission, in short, published yesterday, has been challenged. The writ application was in respect of appointment of upper primary teachers, for which Commission has in the meantime taken steps to compliance with the order passed by this court, publishing new interview list within the time granted by court. The writ petitioners have filed one supplementary affidavit, affirmed today, 9th July 2021, annexing part of a list published by the Commission on 8th July 2021, and prays for certain reliefs, including stay of all further steps relating to personality test by the Commission, pursuant to the interview list published on 9th July 2021. In this matter, I decline to exercise my discretionary writ jurisdiction, refusing the relief prayed for. Instead of the petitioners are granted liberty to approach the commission by filing representation individually, not jointly, ventilating grievance. The representation containing the grievances has to be filed within a period of 2 weeks from date, either through email or by filing a hard copy of the Office of the West Bengal Central School Service Commission. If such hard copy is sent by post, it must be by speed post or by registered post, with acknowledgement due, for which the track record of India Post is to be collected and kept by the candidate. The Commission will consider the representation through any of its officers, not below the rank of secretary, by giving the representation filling candidate an opportunity of being heard, and will pass a reasoned order thereafter. The order will be sent to such candidates by speed post or registered post, with acknowledgement due. The whole exercise as aforesaid has to be completed by the Commission within a period of 12 weeks from the date of receipt of the individual representation. This order was taken on appeal, your lordship, and I will take your lordship my lord, the first, my lord, order passed on by the Honorable Appeal Court. Your lordships will find it that at page, my lord, 109. The longest constantly, your lordships. I will take your lordships, page 112.
Yes.
1. Since an identical question of law is involved in these appeals, all the appeals with their connected applications are taken up analogously by consent of the parties. The facts show that a cry has gone out for appointment to the post of upper primary assistant teachers, and the cry is getting louder by the hour since appointments have not been implemented for a long time following the conclusion of the first selection test of UP upper primary assistant teachers held in 2016. Coincidentally, both the appellants who were the writ petitioners before the Honorable Single Bench want appointments, as well as both the state and non-state respondents want the vacancies to be filled up, considering the dire need for trained upper primary assistant teachers coupled with employment opportunities. It has thus become imperative for this court to separate the signal from the noise of this litigation. Under challenge in these bunch of appeals is the common order dated 9th July 2021.
You can place the relevant portion, Mr. Hanna.
Relevant portion, your lordships, I take your lordship to the argument of the parties, your lordship, then I have to place the arguments, your lordships. Otherwise, your lordships will not get the points involved in the matter.
Yes.
My lord, 113. The arguments of the parties run as follows. First, by notification dated 20th September 2016, the selection rules of 2016 for recruitment of upper primary assistant teacher was published. Important to notice for this discussion is Rule 12 thereof, which inter alia instructs the Commission to prepare a general list of eligible candidates on the basis of a computer-generated database. Rule 12, through its various subclauses, also permits the Commission to verify the validity of the TET certificate and other academic cum professional qualifications of the candidates in the manner as mentioned in Part 1, Schedule 2 of the rules. Part A, Schedule 2 of the rules specifies that for each category of eligibility qualification or certificate held by the candidate, the actual marks granted would be weighted by a weightage system which will apply to all candidates claiming eligibility. It is also provided that the final interview list shall show the respective merit position of the candidates on the basis of their weighted marks in terms of Part A, Schedule 2, to which the marks in the personality test shall be added. The number of candidates to be called for the personality test category Y on the basis of the merit as determined by the procedure to be followed under Part A, Schedule 2 shall be in the ratio of 1:1.4 of the final vacancy position. Well, this will be placed before office while I will be out. Mr. Sandal, Mr. Bhattacharya, Mr. Choturbedi, learned counsel appearing with the other learned advocates, the appellant submit that by a detailed judgment, order dated 11 December 2020. I just say tell you
Yes, yes, that was the
earlier round of
just
litigation.
for the judge.
Just one, earlier round of. In a batch of repetition, a single judge cancelled all selections to the post of upper primary assistant teachers. And at paragraph 30 thereof directed the fresh selection process of the candidates found to be eligible under Rule 12.2 should proceed onwards from the stage of commission, verifying the validity certificates and qualifications as laid down in Rule 12.3. It was made inter alia clear by the Honorable Single Judge that the database and selection of eligible candidates for verification must consist of all candidates applying online for the selection process. And the Honorable Single Judge was further pleased to lay down a specific time frame for completing each stage of the selection. The learned counsel for the appellants primarily submit that it would appear from the pleadings placed before the learned single judge that the weightage was directed to be granted mandatorily under Part A, Schedule 2. By way of illustration, this quote is taken to the list of certain successful candidates who have been called for personality test to demonstrate that the weightage has contemplated by the Rule 16 rules and directed to be implemented by the judgment and order dated 11 December 2020 appears to have been followed more in the exception than in the rule. It is submitted by comparing the position of some of the appellants that their actual marks as received in their certificates as well as in their academic and professional qualifications. In the event, the weightage as contained in Part A, Schedule 2 would have been granted them. Such candidates, the appellant would be eligible for personality test by reason of their superior position in the merit list. It is the specific statement of the council that the documents hitherto put on record in the appeal and also before the single judge shows that in some of the cases, such as Nitai Mondal, the grant of weightage would not follow Part A, Schedule 2. Then, my lord, the personality test issue was argued, and then other arguments. I take your lordships straightway to the ordering portion now, because in course of time, if required, my lord, I will take your lordships to this order. Your lordships kindly come to running page 118. Straightway, my lord, the operative portion of this order.
Yes, yes.
Lord, having heard the parties and anxiously considering the the materials placed at this stage, this court by of an interim order directs as follows. First, the commission shall continue to hold the interviews of all candidates whose names appear for the personality test. Second, the commission shall conclude the interview, grant marks in the personality test, and prepare a panel of the successful interviewers. Third, the commission shall not grant appointments from the panel of successful interviewers without the leave of the court. Interviewees. Fourth, the commission shall prepare a clear database of the successful candidates in the personality test, which shall include amongst others this actual statutory marks of the individual candidates in terms of their certificates, qualifications specified by Rule 12 of the 2016 rules, plus the weightage given against each such actual and statutory marks, plus the marks obtained in the personality test. And on the basis of such procedure, their individual relative position in the combined merit list. Fifth, the commission shall simultaneously proceed with the redressal mechanism set in place by the Honorable Single Bench of the aggrieved candidates. Sixth, at the end of the time period for completing the grievance redressal mechanism, the commission shall produce charts in respect of the aggrieved candidates containing their actual or statutory marks, the weightage granted against each of them under Rule 12, and keeping the space for personality test marks blank, as well as stating any other issue of the particular relevance to the aggrieved candidate. Seventh, on the next date, the commission shall place both the combined merit list data base of the candidates actually interviewed in terms of the direction given above, as well as the database reflecting the redressal mechanism of the aggrieved candidates before this court for further directions, if any. The commission should also maintain at its disposal for production before the court when necessary the original database of the merit listed candidate at the time of filing their applications for selection in 2016. It is made clear that equity shall not be created in favor of any party by any of the actions taken above. The direction in the order are in fulfillment of mandate of Rule 12 of the Rule 16, which stands affirmed by the judgment and order of the Honorable Single Bench. The commissions will keep its grievance redressal portal open till such and such after 12 weeks. These were the orders. Initial order passed by the Honorable Appeal Court. I take your losses from
Yes.
thereafter your lawsuits from time to time matter has been taken up. I will take, if necessary, when I develop my arguments, only those order of the Honorable Court. 3 affidavits after this order has been filed by the Commission. I broadline 3 points I argue before your lordships mainly. First, your lordships, manipulation in the OMR sets. Manipulation in the OMR sheets, they have divulged. This has not, in the earlier round of litigation, they admittedly said that they have reviewed or reassessed all the OMR sheets. Kindly visualize.
Pertaining to the teacher.
Teacher eligibility of 2015. I stress upon the word all candidates. All candidates. After that was the earlier stage. That was, my lord, ordered by this Honorable Court to be absolutely illegal. Therefore, the point comes whether they can again review. This review, I tell your lordships, according to us, if at all, without any notice to us, we are, my lord, having our online mark sheet. Still, we are holding. We filed our application pursuant to the recruitment process on the basis of marks as assigned by them to our mark sheet.
That is of date 2015.
Date 2015.
The earlier one.
Earlier 12, my lord, according to them, nothing is available. They have not reviewed anything. But there is still point.
How was that issue answered by the learned single judge?
Learned single judge, this was not disclosed before the learned single judge.
So,
this has come up before your lordships after this process has been taken by the commission itself.
So why didn't you take that point?
I did take this point because they diverged, because
where you were party to those litigations before justice when the selection process was turned down.
I was party. Rajiv,
so you did not raise that issue before?
Yes, I raised that point. This is, my lord, the learned single judge, Justice Bhattacharya, was the entire selection process on the basis.
No, this relating to the TET.
I tell you, lordship, the first round of litigation, it came to the knowledge of the court when they came up with that there is, I allege, kindly look, this is the application from X. His weightage should be 10. Kindly see, he has been given 20. For example, I'm saying, they divulged on affidavit, and this is the submission of the then learned Advocate General. Now, he's again our learned Advocate General, that this has been done after reassessment of the entire OMR seats of all candidates. Then we came to know, then we took a point that reassessment, how could you do it? Our mark sheet or our marks you are reviewing without notice to us. And what is the necessity of it? Who asked you to do it? You are a recruiting body. There are dual functions. State are held by them. So long the state held, this is one aspect.
No, after reassessment, what happened?
What happened? There is a mark.
Your marks come down.
Somebody's marks come down.
So you show us which are the candidates.
They didn't disclose it before the court.
They filed the affidavit.
No, this is second round. I'm taking first round I'm talking about. First round they did not disclose anything. We took the point that this is an illegal action. Court said you can't do it. This is first time closed.
You cannot reassess.
You don't have the power to reassess like this. I tell you, lawsuit. Reassessment can be asked for by a candidate.
Very good. Then this reassessment was done.
They have, after the division bench order, they proceeded with the selection process.
No. Justice Bhattacharya's order was appealed against.
That was affirmed.
That was affirmed.
That was affirmed.
What had been the statement pertaining to this reassessment?
Well, they again same thing. The court said, no, you can't do it. I will take your losses to that part. I will take your losses to your losses since first time hearing this, obviously.
The Justice Bhattacharya's judgment was never appealed by SSC.
No, not appeal. Somebody
You're not saying that.
third candidate. Third
But
party.
can appeal, but
Third party.
SSC confirmed that we shall comply with the order of Justice Bhattacharya.
Possibility.
That is what they were doing, na? They were doing that when further allegations came.
Yes, while they are doing some revelation, further revelation.
Now your losses, they, my lord, after the learned single bench, the learned Justice Bhattacharya said, you start from the stage of 12-2. I will take your losses to rule 12. Verification stage. Now, my lord, this is the judgment your losses after that. After the order of the division bench, they came up with 3 affidavits from time to time. I tell you losses. According to them, total vacancy 14,000 and odd. They have to call for your losses 1:1.4. It takes X to 20,000 and odd. They didn't get that much of candidate according to them, as I find. They get malad hardly 17,000 all. But even these 17,000 have been reached by them after malad that mechanism directed to be followed by the division bench. Then what they did, they came up with an affidavit before the court, division bench. Look, we have reassessed the OMR seats and we have found these candidates are not eligible. What they have said in their application form, they have not get it. So we want to delete 1,400 odd candidates. And in place of them, somebody comes. But your losses kindly, they have been holding the mark sheets. Now, first affidavit, they say your losses, 273 candidates, 253 candidates, their mark sheet is not at all, malad, they do not accept their mark sheets like that.
Or Mr. Sharnal, you proceed otherwise.
I tell you. Malad, I think, malad, may I take your losses to the Bhattacharya's judgment, some of the parts. It will help your losses to ultimately to consider. Malad, Justice Bhattacharya's judgment, your losses will be getting it starting page 30. I will not take your losses the entire judgment. It's a longest judgment. Only the relevant portion. Your losses will have some glimpses of it, how the matter going on before the Honorable Court. Malad, your losses kindly take malad page 36, para 3 of the judgment.
Yes.
Malad, there are your losses will find 6 points have been noted by the Honorable Justice Bhattacharya.
Yes, that
Malad,
you can skip.
Skip now with the 6 points. Then your losses will kindly come to page malad, if I 44. 44. Running page, malad, handwritten page 44.
Answer to the question.
Well, I have to place it. Kindly allow me to place it entirety because this is the another basic point. It goes to the root of the matter.
Yes.
The contention, lesser qualified candidates with inferior academic qualifications and lower teacher eligibility test weightage have been included in the matter.
Mr. Sharnal, first take us to the rules.
Rule
12 you place.
Just your losses, kindly come to paragraph 1, page 1. Instead of rule 12, I take your losses from the very beginning so that your losses can get an idea about the rules, all the provisions. Rule page 1 start your losses. Your losses in this bunch, your losses will get it. In this bunch. Your losses, the very first one is the rule.
Yes.
I take your losses to the definition clause first. Just have a glimpse of your losses. 2B category. Kind level of means subject category. 1 subsection B, subclause B.
Yes.
Category means subject category, medium of instruction category, reservation category, and gender category. In each subject group or in physical education or work education, as the case may be. Clear, losses? This is the definition of category. Your losses kindly come to Interview list. E, clause E. In respect of SLST means, in case of vacancies other than physical and work education vacancies, a list of candidates to be called for personality test category wise or on the basis of merit. E, at the top.
Interview list.
Interview list.
Yes.
In respect of SLST means, one, in case of vacancies other than physical education or work education vacancies,
Yes.
a list of candidates to be called for personality test, category wise. But we will be harping on this, that this should be limited to the category. Merit amongst the category wise candidates. On the basis of merit, within bracket, my lord, weightage of TET, academic and professional qualifications, in the ratio of 1:1.4 of final vacancies. Then your loss is 2. 2 you are not concerned with because your loss is, this is not a physical education. Then your loss is merit list. F1, in respect of SLST means, in case of post other than physical education and work education, a list of candidates prepared category wise on the basis of merit, within bracket, weightage of TET, academic and professional qualification, and marks obtained in the personality test from the interview list. But between two your losses, the only difference your losses adding of personality test marks in the merit list. Otherwise, both are the same. In the same language you lost. Then your losses panel. Then your loss panel means a list of candidates category wise of the merit list equal to the number of final vacancies and includes a panel reason wise on the basis of the option exercised by the candidates. So your lordships will be getting 3 stages. Interview list preparation category wise on the basis of merit. Merit list on the basis of in respect of category wise on the basis of merit, and my lord, the panel.
In the interview list, the marks have to be given.
But academic qualification marks, state weightage has to be given. On the basis of that, the preparation of interview list is.
So that is a disclosure provision is there.
Yes, yes, yes. Schedule A, part A, Schedule 2.
That is the quantification of marks.
No, my lord, each marks has to, what are the marks to be assigned, that statutorily has been fixed.
Yes, yes, but that appears in the interview list.
Yes, yes. But interview list subsequently they have disclosed. Initially they did not. At the intervention of the court, they have disclosed.
Marks.
Marks. Now your losses, therefore, the three, then panel. Your losses, therefore, 3 stages broadly: interview list preparation, then merit list, and then panel.
Yes.
Then your losses, my lord, kindly come to clause J. Reserved category.
Now, in this new selection process, up to the mark, waiting list have also been prepared. You were there in the first list, which was challenged, which was struck down. Now, the second list, which has been prepared, your names do not feature in the merit.
No, some of them feature, some of them no.
Then, so far as the persons whose names feature, what is their problem?
Problem, I tell you, losses. Problem will be, so far I am concerned, the Rajiv Brahma matters. Your losses, so far Rajiv Brahma matters is concerned, they are not in the list. They are not in the list. Some of them were in the interview list, some of them not. At that stage, they have come out.
But there are other appeals.
Other applicants, I tell you, lordships. Some of them have been in the interview list, called for interview. After interview, commission comes and by way of filing affidavit says their TET marks is wrong. That do not mismatch with the server of the commission and scanned copy of the OMS. Kindly withdraw.
Mr. Shannan, this way there will be an ever-ending litigation.
Well, I tell you, lordships, ever-ending one thing. If the commission comes and says,
then no selection process can be conducted.
No, this is not that. Unless if I'm an unfair person, I cannot. If I'm fair, I can.
Then what is the wrong with
Well,
the single judge?
I only say if I can demonstrate before lawsuit, this is stark illegality.
The thing which you started before the writ court, this has been amplified now to such an
The
extent.
division bench has entertained it and division bench accepted it because you come and because of the magnitude of it. If I take your losses to the entirety of it, if I take your losses, the entirety of it, the losses will find it. Now the division bench,
what can be the solution, Mr. Shannan? Every time process will be started, 2 writ petitions will be filed, appeal court will come within the zone of consideration of diverse issues.
this was the issues before the learned single bench. Learned single bench, one line order, if your losses even do not get the reason for it.
You are assailing the order of the learned single judge, which said that I should not be the forum, you go to the other forum.
There is no forum.
To the grievance redressal mechanism.
That was framed by the court.
Pardon?
That was framed by the court. That
Yes.
was not, there is no statutory provision of that.
Mr. Shanal, we will listen to your argument. Suppose the Brahmo was not there in the second list. Say in the next fresh selection process, he is not there in the merit list. That is what you are saying.
Not even in the interview list.
Very good. So out of this 36 appeal, we must know that how many names featured in the second interview list and the merit list. One thing, let us try to solve the issue. So suppose out of 36, 12 persons are there. Then they won't be an any manner prejudiced if the process goes on. If the process goes on.
A prejudice.
Huh?
Prejudice.
How?
I tell you. Lord, I give an example, Rajiv Brahmo. Just bear with me 2 seconds. I will be prejudiced. Because the point of reservation. Rajiv Brahmo is a general candidate.
No, as per your assessment, none of your
the entire interview list should be quashed. If that will show your losses, to what would happen?
We are saying that out of the persons who are before us, you say you submitted that many of them are there in the merit list.
That's true. That's true.
Let us understand. So today, if the merit list proceeds, what is your grievance? How you will be harmed that my vacancy may be eaten up by another.
That's what I'm explaining. I'm saying the entire thing is tainted. I'm saying. This is a reservation policy. I am a candidate, general category Rajiv Brahmo. In the general category candidate, last marks secured last candidate at the interview list is more than 1 point mark. I am less than 1 mark. Visualize what they have done when they have prepared the interview list category wise. They have taken reserved category candidates on the general category list on the basis of merit. Our point is that Indira Sohani's judgment applicable at the time of appointment, not at the preparation of like this interview list. Your lawsuits would not be getting any matter where on the basis of merit, reserved category candidates have been migrated in the general category vacancy.
Did you raise these issues?
Yes. This is from the very beginning the issue.
No, in the writ petition.
Yes, I have raised.
All right.
I'm taking your losses there.
So as finish of the definition portion.
Now your losses P. J, reserved category. The resultant see the definition reserve category. Reserve category subclause J means category of reservation in respect of the scheduled caste, the scheduled tribes, the backward classes group A and B, and physically handicapped candidates. Then your losses, subclause P, vacancy. Vacancy means a
There
vacancy.
is no category under the general category, it's undeserved. It is not reserved. General is not a category.
General is not a,
It's open category.
it's open category,
Undeserved.
open category, undeserved.
It is not reserved.
Reserved. I'm coming to that. Your lordship.
Reward, it is called reward.
Now, P vacancy means a vacancy in the post of a teacher for classes of upper primary level caused by one, creation of a new post, superannuation, death, resignation, transfer, removal or dismissal, or any other reason apart from the above as the state government may by order determine. Then your lordship, my lord, kindly come to Rule 8.
Yes.
The district inspector of school secondary education, the sub-rule 1 of Rule 8, shall, on being asked by the director of school education, prepare a report regarding the number of vacancies in posts, subject group wise, subject wise, medium wise, gender wise, reservation category wise, for the posts of teachers, and send it to the director of school education. Then sub-rule 2.
Why you are taking us to that?
I'm not. I
Whether
you
in
lo-
your cases there is a wrong,
my lord, I tell you, loss. I have two cases.
there is wrong in making vacancy.
Yes,
statement.
yes. I three cases, my lord.
You are going on enlarging the scope of.
My lord, I am not. Kindly do not
We
take.
are saying that there was a fault in preparation of university, in interview list.
My lord, interview. My lord, I take you.
There
My lord,
was a fault in making vacancy.
my lord, interview list to be prepared on the basis of final vacancy list. Clear? Kindly have a look at the interview list definition, your losses.
That
Final
finalizes
vacancy list
15 days prior
has to be
the-
published before 15 days of the publication of the interview list.
Right, right.
My lord, interview list, when the advertisement published was 14,000 vacancies. After 4 years, when interview list published, the same vacancy. I will be showing there are 5,000 vacancies created
So you want those
to
5,000?
be included. That's the law.
So then your parent case is very weak. So you want in.
No. This was, my lord, they do not act according to law. I came before losses at the
You
very
raised this point before this.
So, my lord, all the points except 1, 2, your losses, this is the way.
All right, we finish it up later.
Two, on the receipt of the report under sub-rule 1, the director of school education shall, with due approval of the state government, send the subject group wise, minimum wise, gender wise, reservation category wise vacancy report, compiled reason wise, earmarked vacancy, such post, if any, declared by the state government for any year to the central commission. Then 3-year losses. The report as mentioned in sub-rule 2 shall be sent to the central commission in the following manner. Kindly see your losses. Firstly,
No, we understand your point, Mr. Varun, that 15 days prior to the advertisement notification should be the date for including the total number of
no.
vacancies.
First year losses. Firstly, before the date of the advertisement inviting application vacancy to be declared,
Yes,
they have declared 14,000. Kindly see clause B, rule sub-rule 3. Lastly, 15 days before the date of publication of the result of the written examination or interview list. Here is the interview list we are concerned. So today, if there is interview list published, 15 days before, they ought to have published the final vacancy list. Here, my lord.
So why didn't you include that in the Justice Bhattacharya's order?
That was the earlier. Let me.
But the vacancy will come within the fold of the.
That was there. That was there. That was there. Even here, your lordships kindly consider.
All right, yeah. So this is one of your points.
One of
Then,
your
so if we have understood you properly, since the interview list after a substantive litigation proceeded for 5 years has ultimately been published in terms of court's order, you should bring within the fold of the selection process all the vacancies which are met.
No. I tell you, lordships. kindly, Malad, this is a specific rule. This rule has been prepared keeping in view in mind or keeping in view the provisions of the Right to Education Act. Your lordships will not find this sort of rules in any other recruitment process.
No, what is your
Argument, I tell your lordship. But kindly look at the vacancy.
No, you finish up, Mr. Sandar. Let us continue and finish. You are
Malad, your lordships. Then your lordships. Malad, I am skipping over sub-rule 4. Then 9. Advertisement.
Yes.
The central government shall, on receipt of the report of the reason-wise vacancy under Rule 8, issue an advertisement through newspaper in the state in English, Bengali, Hindi, or any other languages if necessary, as may be decided by the Commission. 2. Such advertisement shall be issued specifying the vacancy, qualification, age, as on the first day of January each year of the advertisement.
We will go through that.
And
we understood your next come.
3 is relevant, your lordships, kindly take note of that. 12. Let us proceed a little slowly, your lordships.
No, clause 3 is that while specifying the vacancies, what do you want to point out in that?
While specifying the vacancies in the advertisement, the Central Commission shall for the state post of teachers publish a tentative number of vacancies. All I am pointing out to your lordships, vacancies published in the advertisement are tentative, not final.
Not final.
At the time of inviting application for state level that have been reported under sub-rule 2 and a final vacancy list at the time of publication of interview list except physical education, work education, on the publication, declaring the actual vacancies that have been reported under sub-rule 3 of Rule 8. Therefore, rule itself mandates that interregnum period any vacancy have been reported or that has been created, that will come up. Your lordships will not find this sort of rule in any other. We are none of us, your lordships, have questioned the very basis of the rules. We are rather relying upon the rules.
All right.
The rules mandated. And I will share, again, I shall take your lordships to the definition of vacancy. Newly created post also coming in between the period. Rule 12, kindly come to Rule 12. Sub-rule 1. The Central Commission shall arrange for proper custody of all online applications which may be received by it against the vacancy. 2. The Central Commission, after receiving application forms, shall prepare a list of eligible candidates for the purpose of preparation of a computer-generated database of all candidates. Take note of it. From this stage, Justice Bhattacharya directed to proceed afresh from Rule 2 stage. 3. The Central Commission shall verify validity of test certificate. Validity of test certificate, I tell you, lordships, initially it was valid for 3 years. Now, subsequently, it was made 7 years. Now it is time to, all the time to come up. It is without any time left. Right. Academic and professional qualifications of the candidates having valid test certificate and marks obtained in TET and other academic and professional qualifications shall be evaluated in the manner mentioned in Part A of Schedule 2. So, this is statutorily said what are to be marks to be given to the candidates. Then, 4. The Commission shall prepare and publish in their website or interview list with all details of the candidates to be called for personality test category-wise on the basis of merit as mentioned in Part A of the Schedule 2 in the ratio 1:1.4 of final vacancies.
Yes.
Then your losses 5. After interview, the Central Commission shall from interview list prepare and publish a merit list category-wise on the basis of merit, weightage of TET, academic and professional qualification, and marks obtained in personality test as per Part A of Schedule 3. Then, Central Commission shall also prepare and publish in their website a panel of candidates, category-wise, equal to the number of vacancies and the category-wise waiting list of the rest of the candidates from the merit list, which were not included in the panel. From the panel, the Central Commission shall prepare reason-wise list of candidates on the basis of the options exercised by the candidates and publish in their website. Provided that the Central Commission shall publish in their website the appropriate answers of the questions for general information. But this has never done by them. They never follow it. This proviso, the Central Commission shall publish in their website the appropriate answers of the questions for general information. They never do it. Now your losses will find, Malad, let us confine Malad rule 3 and 4.
So what is the difference according to you between the interview list and the merit list? Interview list is 1:1.4, merit list will be equal to vacancy. This is the only difference.
No.
Marks
প্যানেল হচ্ছে
panel merit list
ওইটাই চলে আসে
it will be equal. Panel will be
প্যানেলটা হচ্ছে ইকুয়াল টু দ্য
in the merit list. You have answered merit list will be 1:1 or it will be 1:1.4 also.
Malad, merit list according to your losses, Malad, kindly have a look at that, Malad, merit list.
Interview list is 1:1.4.
Now kindly come to rule sub-rule 6.
That is panel. We are saying what is the difference between interview list and merit list here?
Interview list and merit list.
Yes.
Malad, merit list will, Malad, whosoever have the interviewed, their entire merit list category wise will be published.
So that is also in the interview you said.
No,
interview list marks are provided.
Additional interview marks will be added.
Malad, interview list, your losses, there is no personality test mark.
Right.
After interview, this will be added.
Yes.
Then category wise, they will pass. According to
list. The merit list.
No ratio, nothing.
No ratio, because they can't.
Candidates, the number of candidates will remain the same.
Because
Whoever comes to the interview
I see.
will either be in the panel or in the wait list. Nobody will be out.
Because they cannot.
There is no fresh ratio provided
No,
under
no,
the
no,
merit list.
no, not under
So
this rule.
whoever comes to give the personality test, you add the mark and you put.
Accordingly, their rank goes into the
rank will be.
yes.
Now your losses.
Now thereafter the panel will be published qua the number of actual vacancies. Yes.
Now your losses kindly come.
And also waiting list, which will include all the persons who were invited for interview according to the merit situation.
Yes. Yes.
Point 4
Wait for the list for the rest of the
Point 4 is the
Yes.
waiting.
point. That is the waiting. That. Now your losses, Malad, kindly Malad 3. Because this is the first point of reservation. The Central Commission shall verify the TET certificates, academic
Where
and
you are reading?
sub-rule 3. Of
Again you are going back to 3.
Well, that's now, Malad, I've just placed it broadly. Now your lordships kindly see. The Central Commission shall verify the validity of TET certificate, academic and professional qualification of the candidates having valid TET certificates and obtained in TET and other academic and professional qualifications shall be evaluated in the manner in Part A and 1 schedule. Then, Malad, sub-rule 4. The Central Commission shall prepare and publish in their website an interview list. This should not be an interview list with all details of the candidates to be called for personality test, category-wise, on the basis of merit as mentioned in Part A, Schedule 2, in the ratio of Rule 1:1.4 of the final vacancy. My lord, here, my lord, this rule we have to read with the definition of category. Your lordships kindly consider category definition. If your lordships take Rule 2B. Now your losses kindly consider. Category means subject category. Suppose Bengali. Your losses subject. Medium of instruction category, Bengali subject, my lord. It doesn't medium of instruction category means the school. Whether it's Bengali medium school, Hindi medium school, English medium school, Nepali medium school, like that. Then reservation category. Here, my lord, we comes. My lord, suppose I belong to scheduled caste category. Whether I should be within the reservation category or on the basis of merit, I can be also taken into the general vacancy. No, I tell you losses. This is the point. This is at the time of appointment, not at the preparation of the interview list. This is the interview list. I tell you losses why. This is not the final selection interview list. Interview list is only for the purpose of who will be qualified for the interview category wise.
Then what they have done?
They have done, Malad, at this stage, they have included on the basis of academic qualifications and state weightage reserve category candidates against general category. As a result, your lawsuits, reserve category candidates, several reserve categories who are at best 1 or 2 marks, they have not come within the zone of consideration of personality. Consequently, on the contrary, even at the interview stage, vacancies in the reserve categories are lying. The proposition of Indriya Sahani's judgment.
They have not prepared any separate list for SC, ST.
No. They have. They have. After taking on the basis of merit, vacancies within the general vacancies, the rest they have brought under the category. Clear to your lawsuits? Suppose your lawsuits, 500 vacancies are for open category. Now they said open category. That means unreserved category. Now, I got as an open category candidate 10. My learned friend got 11. My learned friend gets a chance in spite of being a reserved category against the unreserved category at the very interview stage, very initial stage. Now, suppose your lawsuit interview stage 10, interview marks 10. My learned friends get 2. If I am called for, I get 8. What would be the situation? Final merit list, it deals with the final merit list. It affects the final merit. Your lawsuits judging that on the basis of the reservation merit even before the selection. This is one of the selection on the basis of academic qualification. That's not the final selection. It can be done, my lord, at the stage of final selection when you are preparing to panel and going to appoint.
Yes.
I will give the examples, your losses to that.
Yes.
Now, then your losses will find 4. Shall prepare and publish in the I placed it. Then, my lord, 5. After interview, the Central Commission from interview list prepare and publish a merit list, category wise, on the basis of it. Here also your losses, my submission, this will be again, my lord, confined category wise. Here also they can't apply merit for the purpose of appointment. Merit, my lord, your losses, this is the law by, my lord, judgment of the Honorable Supreme Court. Your losses won't get any rules that migration. Your losses getting any rules of migration in the selection process. This is a judgment law. If I say so. Judgment of the Honorable Supreme Court is a law. Now your losses, therefore, that principle is applying. If your losses take into consideration the provisions of Article 16, sub-Article 1, at the time of appointment. Therefore, when you are going to prepare the panel, suppose your losses are getting merit category-wise on the basis of list, unreserved category, that means general, scheduled caste, scheduled tribe, scheduled tribe. This is the merit list of all the categories. Now your losses going to appoint. Your losses has to prepare a panel. That panel, your losses, when you're going to appoint, first your losses has to consider open category. Now suppose after interview, out of 20 marks, I have got 16. My learned friend got 17 after interview, taking after conclusion of the file. My learned friend can be included or migrated against open category. I'm not on, I can accepting it. This is the law. But you cannot do it at the interview stage.
Very good. Yes.
Then your losses will find the Central Commission shall also prepare in their, this after interview losses merit list. Then 6. The Central Commission shall also prepare and publish in their website a panel of candidates, category-wise, equal to the number of vacancies. Here your losses, the Supreme Court judgments comes in. According to me, I'm not subject to all of my learned senior submissions. Here your losses, the Indira Sahani comes in. Here your losses can apply migration on the basis of final merit. They have done it, your losses, at the very threshold. Now, my lord, I will take your losses for this. Everybody has, my lord, submitted their losses or written notes of arguments. I will be taking your losses to that, how they have dealt with it. Your losses will be getting it because we reached that point. Written notes of submissions, corrected. My lord, your losses will be getting a corrected copy of the written notes of the number.
No, you are going to written argument.
Because on the reservation point, this is point of law, man. Facts are admitted. They have done it, they have said it. This is point, reservation point, absolutely point of law. Vacancy point, absolutely point of law. The last point I will be taking your lordships, how they can deal with OMRC.
Yes.
That's the ultimate point of this. Now your lordships can take your lordships. Corrected copy list of dates and written note submissions on behalf of the appellants. Your lordships, একটু বার করে দিন, বার করে দিন। এটা
We have a written argument in case of Soumita Sarkar. You are reading that?
No, Ruchira Chatterjee. Ruchira Chatterjee.
The identically.
No, Malad, that probably I have not prepared, Malad. Rajiv Brahmo's matter. You will also dealing with Rajiv Brahmo. You will also kindly take up that.
List of dates, written arguments in Rajiv Brahmo. This one.
I think Malad, অত রোগা হয়ে গেল কেন, থিম হয়ে গেল কেন? একটা কপি আছে, দেন একটা কপি দেন, দুটো কপি দেন, তারপর দেখি দর্শকদের দিন কোনো কপি এক্সট্রা নয়।
নামটা কি বলছিলেন? রুচিরা,
এই যে রুচিরা চ্যাটার্জি। কারেক্টেড কপি বলে একটা দেওয়া হচ্ছে, প্রথমে একটা দেওয়া ছিল, পরে কারেকশন ছিল।
These are your point. এটা না।
Malad, this
Or
is the
any other point.
no, Malad, I have to so far the Malad vacancy. I have to take vacancy point. I have to take your loss in little facts.
The manipulation of OMRC,
OMRC is your
review and reassessment without giving any.
no. First, the review and reassessment cannot be done.
Cannot be done. Thereafter, the vacancy arises in the meantime has not been included, and they have
reservation.
applied the reservation policy erroneous.
If the reservation policy,
For preparation of final, it is the 4 point.
okay.
No more point.
No. And Malad, there are certain points, individual points that your losses take. Achhe, Malad, may I take your losses, Malad? If your losses ignore my notes, can till such time they get it, your losses, let us proceed.
we can ignore your note, but we should not ignore your content, sir.
What?
এত easy কেটেছে।
Malad, page 11.
This you have against Rajiv Brahmo.
Rajiv Brahmo, I am placing.
No, you are saying Ruchira.
Ruchira Chatterjee is the advocate on record.
তাহলে এটা না করে এটা দেখো,
পেছনে বসে
রুচিরা চ্যাটার্জি হচ্ছে না অ্যাডভোকেট। এই যে দেখো না, এইটা দিলেন না।
উপরে রুচিরা লেটার হেড আছে বলে দাও, উপরে রুচিরা লেটার হেড করা আছে বলে।
Malad, I কি শিওর না তোকে দিয়েছে ওটা সার্ভিস, তো জসেফ দে
তাহলে প্লেন দিস all right, place from here.
Malad, kindly come to page 11.
Page 11.
11. First, since I deals with the reservation, I deal with the reservation point first. Your losses can get it. I. At the bottom, your losses will get.
Page 12.
Page 11.
Page
Corrected copy.
না, এটা তো ক্রস চিহ্ন দেওয়া আছে।
হ্যাঁ, ওটা corrected নয়।
Acha, this is your correct. Yes, yes, Mr.
Roman 2, bottom. Reserved category candidates, page 11. Reserved category candidates, SC, ST, OBCA, OBCB, on the basis of merit, academic marks, marks of training qualification, and pay to ethics, has been included and considered as general category candidates at the time of preparation of interview list category wise and subject. This has constituted violation of Rule 12(4) of the rules of 2016, as such inclusion of reserved category candidates in general category violates category-wise preparation of interview list on the merits of the candidates belonging to general category. Here, the merit of each candidate relates to his or her own category. The word category defined in Rule 2J of the rules of 2016, migration of reserved category candidates in the general category on merit, is not at all permissible at the interview stage. Because of this illegal action, lesser number of general category candidates have been included in the interview list meant for general category, and on the category in respect of scheduled caste, scheduled tribe, OBCA, OBCB, PH categories, candidates belonging to the said categories equal to the ratio of 1:1.4 could not be called upon at all. I just explained it to your lordships. I said it, general category means for general category candidates because this is not the final selection. This is not the appointment stage the commission has reached. Had the interview list for general category candidates been prepared only with general category candidates on merit, not only more number of general category candidates could have come within the zone of consideration of 1:1.4 ratio, but also equally more number of candidates in respect of SC, ST, OBCA, OBCB, and PH categories could have been called for interview. This action of inclusion of reserved category candidates against general category candidates, calling for interview on the basis of 1:1.4 ratio, not only constitute violation of Rule 12(4), but also guarantees enshrined in Articles 14 and 16 of the Constitution of India. For this violation, against 14339 vacancies, only 1704 candidates were called for interview instead of 20,075 candidates on the ratio of 1:1. Kindly see how they have filed the result of violation. This illegality goes to the root of the matter and illegal preparation of interview list vitiating the entire process. The next paragraph, Roman 3 only, then I will take to their submissions. According to Rule 12(4), candidates on the basis of 1:1.4 ratio shall be called for interview category-wise and subject-wise. Here, candidates were not called for interview category and subject-wise on 1:1.4 ratio. Your losses kindly come to page 23. একটা কারেক্টেড পেজ দেওয়া হতো সেটা করতে হবে এই লিস্টটা তো না এই লিস্টটা হ্যাঁ একটা কারেক্ট করে দেওয়া হয়েছে আছে কপি নেই
Yes.
Now your losses kindly consider this is one subject wise I have given the example. This have been little corrected copy have been given to your losses, but the other coordinated page I don't know. It's a single page. I don't know where losses will get it at all because একটা copy থাকে দে না
What had been the correction you tell us, we will take it down.
But it is more clarity. I take your losses. Let us proceed with this. They will get it, your losses from there. Your losses will find the total vacancy, your losses at the top will be getting 5055.
This is total vacancy 5,000.
Pure science. Pure science, subject-wise vacancy.
Subject.
I'm dealing with because subject-wise interview list. Total vacancy 5055. Matlab 1:1.4 takes us to, matlab this should be 5055, not 4055. That is the correction. Typography.
Total vacancy is 4055.
There are two corrections, broadly, matlab. And your losses will find if the total vacancy 5055 on the basis of 1:1.4, it should be 5677. Here your loss is 70. These are the two, matlab, broad correction.
5677.
5677.
Very good. Yes.
Now your losses. Well, let us one by one. Category your losses general. Justice Chakraborty by knows in the selection process. Leave your losses.
No.
That male female category is a category in the higher secondary school, and female category. One category male and female. Female can go, but in the female category, normally general categories are not allowed.
Role also, male candidate will not be allowed.
More male candidates will not be allowed. Now, kindly see, vacancy wise, general category on the basis of total vacancy, male female category comes to 1.1468. Female 350. Total general category comes to 2818. Get it, your losses. Then your losses, candidates to be called for interview 1:1.4 candidates required to be called for interview subject wise, category wise, gender wise. In ideal situation, this should be candidates 2055 to be called for male female category. So for female category 490. Had they followed the rules, this should have been the situation. But what has been the situation, your losses will get totally called. Male, female 2101. Your losses will find increase, and female also increase. These increase have taken place because your losses migration of the reserve category. Now, one thing I tell you, losses, if the more than one candidate gets same marks, all will be included. Suppose I got 100.1, my learned friend gets 100.1, and all other 10, everybody will come up. That's the rule. Because everybody got 100.10. I am giving an example. So, considering that the others, there will find your loss increase in the number of candidates called for interview. Then your losses, general and others. We have made the calculation. Broadly, this has not been disputed. This has not been disputed, Commission. General male 1026, general female 931, reserve male and female 1075. So, my lord, these number 1075 have been included in the general category at the interview stage. Saying it, open category. I will take your lordships to their language also, other language they have used. All these theories are applied at the time of appointment, not at the stage of preliminary interview list.
Yes.
Then your losses, the resultant effect your losses can come. Therefore, your losses, so for vacant position, male, female, 1075, we show it, had there been no such inclusion, illegal inclusion of reserve category. Therefore, 1075 general category candidates called for interview. Rajiv Brahmo, the first candidate, is one of such candidates. The last candidate in the interview list gets, suppose your loss is 48, he is 47. Had this not occurred, he could have been in the interview list. There is a interview for 10 marks. He could have got 9. Though the candidate who is the last, he could have got 3. Nobody can say. Then the interview, the selection process completes. Now the question of appointment comes. So before that, they have applied. This is not the ultimate selection, your losses. As your losses find that the interview is a very substantial part of the selection process. The interviewer judges the personality of the candidate, how they explain a subject before the students. That is judged. So before that judging, I am excluded. Just I have short of 1 mark.
Yes, yes, Mr.
Yes, yes.
Then resultant effect your losses would be kindly straightway come to the vacancy position category wise. Malad schedule caste, malad they have called for your losses kindly. Male female vacancy are 850. They have called for 1190. Female 207, female 809. Then your losses will find vacant position total in the male female category, schedule caste category 225, female category 289. These candidates remain vacant. These vacancies for the interview 1:1 point ratio. Because already they have been included, so they are not getting the candidates. This is the situation. Now your losses will kindly come to page 24. By an illustration, I have explained. I've tried my best to explain it to you. Well, I have given one example. I have not given much. Rajiv Brahmo. Madhyamics, he has got 10 out of 10. Higher secondary, 10 out of 10. Graduation, 18 out of 20 probably, if I'm not wrong. Training, 10 out of 10. State weightage, 25.88. Her total comes to 73.88. Your losses, just come your losses. Sridham Mondal. He got total score 77.45. Last but one. Got it, the losses? Total, don't kindly do not take it, the last one in respect of 4, because that is after adding the score. I will take your lottery to Sudip Sarkar, the last one.
Now, what is the total score of Rajiv Brahmo?
Because he was not called for interview. That's why your losses will not be getting it. I am trying to demonstrate it before personality test or interview. What was the situation of the last candidate vis-a-vis Rajiv Brahmo? Your losses will be getting it, Sudip Sarkar, the last candidate from the general category called interview list in the pure science subject. Kindly see 73.47. And I have got your losses total. I am short by just
what is this? How much is
I know, I tell you losses.
73.88.
73.8. Total score before interview. Kindly see your losses. The last, Shubhendu Midda.
After interview also he does not get that.
Shubhendu Midda, your losses total score before interview.
Sarkar, you are saying?
Total score before interview. So for Rajiv Brahmo 73.88.
Right.
Kindly come to third one.
Shivendu.
Shivendu Midda 72.33. Your losses difference is 1.5 like that. Basically, how time?
কি বোঝে ট্রেনিং রাজীব জেনা
না তো দেখা these 4 candidates have been selected in the interview list. Kindly see the last point of note that the marks provided herein above for the candidates as per application form 2016, who were less meritorious candidates than the applicant Rajiv Brahmo. But the West Bengal School Service Commission unlawfully modified or increased their marks to illegally call them for interview and facilitate them the position of in the provisional.
So how can you say they are less meritorious at the end of the day?
I tell you, at the end of the day, your losses kindly see total score before interview. Mine is 73.88. Kindly see Sridham Mondal. Total score before interview. All of them.
He shall not be called if trained available.
Untrained, another aspect. Matlab, they argue that at the time of interview, it was found that they have got the training qualification before the last date of the application. Matlab, how could they know it? I don't know. Matlab. That's another point.
No, before interview, marks of Rajiv was highest if compared to this.
But he was not called for.
Because he didn't come within the zone on
But-
the basis of 1:1.4.
Matlab, then how could they come? Matlab, I don't know. The rest four.
That is what we are saying. That
That's not one of the point of mine. I'm giving an example. That's one of the point. But I can show you lots
then Rajiv was not called for what reason?
for the interview at all.
No, that is for what reason according to you?
But according to me, I have not come with
Had the reservation
Exactly,
appropriate.
that.
That is your view. He is a general category.
General.
Hmm.
Now kindly see, my lord, the commission's reply to this. Put it down. And annex, Lord, I take your losses, my lord. This is your losses. Law notes on behalf of the School Service Commission.
Mr. Sanal, this subsequent selection process are being undertaken on the basis of the order passed by the Justice Bhattacharya.
Yes, your lord.
Now, Justice Bhattacharya's a time-bound manner stated that when the commission will prepare interview list. So the vacancy statement up to preceding 15 days, the vacancy arises up to before 15 days, that would be the final vacancy.
From 15 days, your losses counting from which?
We are proceeding, going back to the date for
No,
final list, but that was not done.
entire thing was set aside, man.
Come to page 81.
Reservation. Say the okay.
15 days from the date of application of the interview list.
I beg your losses.
Shall prepare the interview list by 10th May 2021.
Selection process
Interview list. The vacancy
Up to 10th May.
arises up to 15 বাদ দিন।
Well, I invite that. I invite that. That's our case.
We understand it.
কমিশন একটা মানে রেসপন্ডেন্ট একটা ঠিক আছে তো থাকবে না আমাদেরটা নোট করেছিল তো দেয়নি জজ সাহেব নোট করেছিল বলে দেয়নি
তো ভ্যাকেন্সি কম হয়
বন্ধ করে
বলেনি Yes, Mr.
Yes.
But kindly come to, there is no pagination of Dr. Pathur. At the bottom, I'm sorry, page 7 of the written notes.
Oh, Mr. Sannal, pausing here for a moment, why don't you ask your junior to prepare the list of those reserved category candidates who, according to you, had been deprived by this process followed by
How
them?
do I know? They have not disclosed it.
You don't know the...
No. I have calculated it with great effort, but I can't tell you losses the names and details.
They are your clients. They are your clients, na? You have to work for your client.
They are not. Probably they Oh, I don't know, Malad.
Unless you please assist us, do this homework.
No, I can homework, Malad. I can probably get the data. Malad, Dr. Patto can immediately jump up and say these are the candidates or reserve category candidates were included in the interview list. Immediately they can say. I can draw you give Malad if I get the data.
All right. Yes. Next, what is your next point?
This reply to the commission to this point.
That
it will minimize your losses time, your loss.
That is here.
Well, in the your losses. This written note of the commission.
Wait a minute. I will do. This is again amended.
Yes, sorry. Amended. Amended. You can
What is there? You tell us now. What is their stand?
Well, kindly read it your losses because this is a reservation point.
এটা পেয়েছো এই পান হেল্প করে দাও না এই যে এরকম অনেকটা
তাই না সাবমিশন গুলো
yes which page you want us to go
internal page 7
এটা আপাতত দাও
এটা দিন না জজ সাহেব এটা দিন এটা আমাদেরটা দিন কাজটা তো চলুন
internal page 7
under the heading violation of reservation norms by permitting migration from reserved to unreserved category. Your losses will get the pagination at the bottom of the page. 7th, point number 12. On behalf of the appellants, it is urged that the reserved category candidates have been treated as general category candidates at the time of preparation of interview list. This kind of migration is impermissible. According to them, such inclusion violates Rule 12, which contemplates category-wise interview list. Rajiv Brahmal. Then Malad, paragraph 30. It is submitted that the said contention cannot be accepted for the following reason. A. The migration of reserved category candidates to unreserved category is not a violation of any statutory rules or the law in general. Kindly. But therefore, migration is admitted. They say this is not violation of rules or rules in general. Rules in general, as I know, Malad, that the judgment of the Indira Sahanis and subsequent judgments. Then your losses Rule 12, B. Rule 12, sub-rule 4 read with Rule 2EI of the rules provides for preparation of the interview list category-wise and on the basis of merit. Then C. On a proper reading of the said rule, it would appear that they only provide that a merit list ought to be prepared as mentioned in Part A of the Schedule 2 of the Rule 2016, and the names of the candidates appearing in such merit list should be organized category-wise. However, the said rule cannot be read in a manner to make the unreserved category a closed category, meant for the people who do not belong to reserved category. It is now settled law that the unreserved category is an open category, and candidates belonging to reserved category can be placed in unreserved category if on merit, and they fared better than the least placed candidate in the unreserved category. But kindly visualize now the language fared. Is it the stage for consideration of my fairness on merit, or it is to be considered after interview list and after my interview text message? Because my merit is not, judging of my merit is not complete. It is in the midst of this selection process. Category, now your losses kindly see, visualize rule, sub-rule 4, category-wise. Justice Chatterjee once told in the discussion, your losses, there is general category not mentioned. Absolutely correct in the rule 4. Then means category which have been mentioned. You prepare those category-wise. Left is unreserved. Left is unreserved category for the unreserved. You have prepared for the category-wise on merit. Who do not come on the basis of 1:1.4 regarding their reserved category vacancies. They cannot be brought in over there.
No, why do you say that they cannot come within their particular category of SC, ST, OBC?
Well, I tell you, lordships, they can on the basis of merit. Suppose your lordship category-wise vacancy SC 250. This will become on the basis of merit. First 250 goes. Now suppose there are at the bottom there are other candidates who have not come against the 250 vacancies. Suppose some of the candidates are better than general, they can be included. That not permissible, man.
So whether they are better than general or not, that can be ascertained only after
Final selection.
This is your argument.
That's only at the final stage of study. Otherwise, it will be havoc, my lord. Consider it, my lord, from any angle, your lordship.
All right. Yes. Next,
your lordship. D. Further, it has been, my lord, the judgment of Indira Sahani, both of us have relied upon. The commission and we. I will take your lordship to that judgment. D. It has now been held by the two decisions of two different honorable division benches of this court that the migration of reserved category candidates to unreserved category even is permissible, even after they availed of relaxation age and fees to become eligible to participate in the selection process, and if the standard of assessment is the same for the reserve. Well, this judgment is totally misplaced. I tell your lordships. This is again factually after the selection process this point came up. I suffered the judgment. I owned before the tribunal, suffered before the division. Here, my lord, the point was, my lord, that certain candidates took the concession of age relaxation, schedule time. By virtue of the latest Supreme Court's judgment, my lord, even the age concession is a concession, and therefore, after availing of that concession, you cannot say that on the basis of merit, I can be migrated to general category at the time of appointment. Malad, I am distinguishing these submissions on the basis of 2 points. First, these cases both where the law, Malad, migration was done at the time of appointment, not at the time of initial selection or like that. Not at all. Secondly, Malad, this is a case where concession was given. Supreme Court says, Malad, in other views are being changed. From day to day. Today, one of the views of the Supreme Court.
After concession, they were placed in the unreserved category.
Yes. At the time of appointment. Now, court says, our division bench says.
So that you cannot eat up that by coming to that, they would be eating up the vacancies for
general category. Now, we lost on the point that age is not on the basis of merit. The time has come up to consider. I wanted to develop, but I have not been able. The point is that your losses, suppose we are the lawyers. We take your losses sometimes take into consideration our seniority. Even if your losses sometimes taken on various selection process. So seniority is one of the age. Now, suppose I'm a schedule caste candidate. I take the age concession of 5 years. I'm 35, he is 43. I'm 38, he is 43. Just because he is a schedule caste candidate, it cannot be said that belonging to he has not got the experience clause because of the 5 years expiration. He has become more experienced than me. He is also a human being. But this argument probably I could not properly place before the division bench. It's my incapability. But so division bench confined this argument. If you take the advantage on merit, that means your lordship, a candidate having got 45 marks, for the general 50 marks, you have come within the zone of consideration at the very initial stage. 5% relaxation in marks is given to all as you lost in law. If you avail that, then you cannot mind, but not on age. But my views are different, but even your loss, I lost it, though I own before the tribunal. So these principles, my lord, cannot be applied over here. Then your lordship, next page E. Further, the reserve category candidates could merely avail a lower qualifying marks in the TET exam so as to be eligible to participate in the selection process. However, there was no relaxed standard in assessing the candidates once found eligible, and the same standard as specified in Schedule Part A has been applied to all candidates. In this regard, it is submitted that mere participation of lesser eligibility criteria, even by of a lower TET marks, has been upheld by the Honorable Supreme Court to not be a relaxation in the assessment standard. Migration was held to be permitted from reserved to unreserved category even after taking advantage. Malad, I take your losses to the judgment. This is again Malad misplaced. First, I take your losses. This is the judgment. I tell your losses. But the question arose, Malad. So far, TET qualification is concerned, I just make it your losses for clarification. TET qualification for general category candidates, 90 marks is the state qualification. For the reserve category candidate, it comes to 82, 83. Now, the point arose before the Supreme Court, a candidate who got 83% marks in TET, he has got a concession. Now, how he can be allowed to be migrated in this selection? Supreme Court says this argument is fallacious. For the reason I tell you, Lordship, really fallacious. TET is not a selection process qualification. TET is an eligibility criteria. If I do not qualify TET, I cannot apply. Now, even after application, TET weightage, suppose I got 83 as a scheduled caste, my learned friend got 90. Weightage would be always reduced so for state scheduled caste category candidate. Because weight I got 83, it has to be weighed with the 100 or 150 total marks. So always I will get reduced weightage. So I didn't get any benefit. But even in spite of that, if I get a marks in the selection process more than the general candidates, Supreme Court says there can be a migration. But even this migration, also at the time of appointment, not at the preparation of the interview list or other. But even there is no such rule even. The interview list will be prepared like this. So this judgment also, my lord, is a misplaced judgment. I will take your loss if necessary. These are the submissions so far. The reservation point is concerned.
Yes, next point.
At the last, I will take your lawsuits to the judge. Now, let us take your lawsuits to the vacancy point. Kindly come to page 13 of my written notes.
Now, you participated having seen this advertisement. Today, what analogy you are bringing out by the basis of the explaining your argument, this ought to have been raised at the time when the door for appointment opened, that is at the TET stage. At the TET stage, 12.3, this provision which you are saying, this migration concept, which is, you're saying that it should be from the date of appointment. These arguments were never advanced before Justice Bhattacharya.
Justice?
Bhattacharya.
Justice Bhattacharya's argument, this point, that was not the case at all. Where the case was,
let us forget, accepting your argument that may be not the case at all, but this is a very serious issue which you are raising.
That's your loss.
So we have come after crossing the first street petition by which it was gone.
I tell you, losses. State was different thing. State is not involved here.
Selection process was
Selection process after the advertisement.
Yes.
After the advertisement, I just explain it within a second.
Before Justice Bhattacharya, the panel was prepared.
Panel was prepared. But
now the panel was struck down.
Struck down, I tell you, lawsuits.
On the points which you have argued.
The points involved. Suppose your lawsuits, 2 lakh candidates were applied for. Suppose 2 lakhs. They verified only 40,000 and they said this is sufficient. I was for the rest. The
40,
commission.
40,000 means?
Candidates' application was verified. The rest were not at all verified.
We are not on that. We are asking you whether this point was argued before her ladyship.
This point was argued.
Please show us. Please show us that you will. Please take us to that.
Before that, I will show in course.
This vacancy issue and this issue. How this lordship has, her ladyship dealt with these issues. Your senior knows, you need not brief him further. He knows the issue. Yes, you take your seat. You take your seat.
I take your lawsuits. Here, these violations takes place.
We will question you in reply. Let us see what the reply comes. Now, what is the next point you are arguing?
Next one. Kindly allow me to also to go to Justice Bhattacharya's judge after placing this point.
Yes. There are 4 points you are arguing. Reservation you have finished.
I just place it to losses the arguments, then I will. Now, kindly come to my written notes of argument, page 13.
Page 13.
My notes, your Lordship.
Yes. No. এটা তো reply. ওইটা না, ওটা হলো opposition. Page 13 you are saying, Mr.
No. My note.
Yes.
Point number Roman 4 and 5. You'll also kindly see. Violation of Rule 8.3b and 9.3 of the rules of 2016 on the part of the West Bengal School Service Commission takes place for not including up-to-date vacancy in the final vacancy list.
This argument we understood. Your argument.
Kindly allow me to factually. I have to show the vacancies occurred. And,
yes, admittedly.
And they are a defensive lawsuit.
No, have they disputed the number of vacancies which occurred, you are saying?
No, they did not. But the argument I should deal with it. Otherwise, your lawsuit, you will not be in position to deal my argument. I tell you, lawsuits, kindly consider. By not calling the candidate on the 1:4 ratio. The final vacancy list as published by the Commission is contrary to the order dated 11th December 2020 of this Honorable Court and violative of rules 8.2, 8.3 and 9.3 of the rules of 2016.
11 December is appeal.
That's Bhattacharya's judgment.
Oh,
11 December 2020. First point, list of vacancies not published 15 days before of the publication of the interview list as per Rule 8.3b of the Recruitment Rules 2016. Then, final vacancy list published by the Commission in contravention of the requirements of Rule 8.2 and Rule 8.3b, read with Rule 9.3 of the Recruitment Rules 2016 as no report obtained from the Director of School Education as to number of vacancies available. subject-wise, medium-wise, gender-wise, category-wise, prior to publication of the final vacancy list on 21st June 2020. And this is evident from the 2 points. A, in the advertisement published in the year 2016, total vacancy declared was 14088, including 10% para-teacher vacancy. Whereas in the notification dated 21st June 2020, well, this is the publication of the vacancy list. The total vacancy disclosed after Justice Bhattacharya's judgment, total vacancy disclosed to be 14339, excluding 10% para-teacher. And therefore, there has been an increase of only 1660 vacancies between the period of the date of advertisement 23rd December 2016 and 21st June 2020, publication of the final vacancy list.
Publication of final vacancy list as per 83B is 15 days prior to publication of the result of the written examination or interview. So interview list was published 15 days thereafter.
Yeah, after the publication of the interview.
Vacancy list.
In vacancy list published after the publication of the interview.
Under which provision?
83B and 93.
93.
93. 83B and 93.
83B is 15 days prior to the date of publication of result of the written test or interview.
Here, Malak, no written test, interview list on the basis of academic. They published first and then published the vacancy list.
They published vacancy list later. Yes, next.
Then your lawsuits B. Inclusion of only 1660 vacancies during the aforesaid period of almost 5 years is not correct and violative of the aforesaid rules 8.2 and 8.3b of the rules of 2016. As the learned advocate for the commission by letter dated 11th August 2020 informed the Honorable Chief Justice of this Honorable Court while praying for constitution of special bench for hearing of the writ petitions as to existence of 5001 normal vacancies, more vacancies reported to the commission in the meantime, and also the Commissioner of School Education further intimated the board by letter dated 15th February 2019 as to allotment of further 1508 vacancies of teaching posts in 1703 number of new set up upper primary schools in past graduate category. Therefore, the above 5108 vacancies for new set up upper primary schools, apart from vacancies which have arisen in the meantime, but not disclosed and included in the final vacancy list by the West Bengal School Service.
Yes.
But I have to take your losses to these two communities. 230.
It's on the page 230. 213 হচ্ছে কমিশন ডিক্লেয়ার্ড 14,339। তারপরে কমিশন পাবলিশড ইন্টারভিউ লিস্ট, সেটা তোমার পাতা রয়েছে। তারপরে ইনক্রিজ করলো সেগুলো পরপর
আপনার এটা নিয়ে আমি বলে নিই আপনাকে দিতে।
মানে পাতাগুলো মেট্রিক করে
তো ঢুকায়নি। Finalize selection process of all the candidates who have found to be eligible. Eligible হচ্ছে এত or say 100 of yours relating to vacancy.
Increase of.
Next,
but I take your losses to certain point. Your losses kindly take up our stay applications. The documents I have to show your losses.
Documents pertaining to,
the vacancy.
you have mentioned,
Malsa, the document itself. Your losses, kindly see the nature of the documents.
yes, which document you are referring?
No, my lord,
So
kindly
this fact is admitted, Mr. Sharma, that there had been enhancement of vacancies. They have conducted it on the basis of the vacancies which were declared earlier in terms of that 832 A. Now, ultimately, on the date the interview list was prepared, by that time further vacancies has
They
occurred.
say, my lord, they have included, and that is 1660. They further say, kindly take up your losses, my notes of arguments, page 14.
What is their stand?
Their stand, your lordships, they have included 1660. They are to consider only those vacancies which are called anticipated vacancies or vacancies which have arisen in the meantime by death, by superannuation.
That they have included.
According to them. My case is, your lordships, that there are other vacancies by creation of new posts. And that is
so your contention is that the new post vacancies should have been included in this selection process.
And also, my lord, the other vacancies which have 5,000 more.
Which
Therefore,
is that?
That's two documents I'll be taking for to your losses. Their documents, not our documents.
No, they have included the vacancies which had occurred prior to 21st June 2020. That is what you are saying.
As the submission of the commission.
Then what is your grievance? That over and above that, for
over and above, along with new setup schools.
New setup. Now, the new setup is how much? New setup is, according to you, how much?
5,108.
5,100.
5,001.
দেখো এই দুটো আমি করেছি, কারেক্ট মি ইফ আই এম রং। 14,339 প্রথমে অ্যানাউন্স করেছিল, তারপরে 5,001 ওদের চিঠিতে বলেছে, হ্যাঁ, তারপরে 5,108, সব শুধু 24,448।
They have declared vacancies 14,000 and odd.
No, what was the declared vacancy? 8283A.
83A, 14088, including 10% para teachers. Your losses will be getting
yes, you
page
just
14.
140, yes.
Including 10%.
Achha.
Then your losses, whereas notification dated 21st June, that is after the verdict of the court, the total vacancies declared 14,339.
No, they
14,339. 14088 is the paper advertisement vacancy. That is 2016.
Right.
After courts, that is tentative. After court's verdict, they published a fresh vacancy list that in Malad shows 14,339, in excluding para teachers.
So there was only enhancement of about 300.
No, enhancement of 1,660. I tell you, losses why. Because 1408, including para teachers, 10%. Therefore, we have to minus 10%. Therefore, my lord, therefore, your losses will find at least 13,000 and odd has to be 1,300 or odd, 1,400 approximately have to be excluded from that. Now, after the judgment, they published the fresh vacancy, final vacancy list. That shows 1439, excluding 10. Therefore, your losses total increase in the vacancy from 16 to 2020 for 5 years, 1660. I have explained it in page 14. You'll also very fast paragraph.
Very good. Now, thereafter, they took into its fold further vacancies.
Well, before that, there were vacancies. I will take your losses to 2 pages only.
Before that means before what?
Before publication of the final vacancy. In Amalat on 21st June 2020. I take your losses to documents.
Please tell us, on 21st June 2020, 14,339, including 10% para-teacher. Excluding 10%. So with after these 5,001 vacancies which you referred to in paragraph 3, this was again included.
Not included. This should be included. This should be included. They have not included those vacancies. Those arrows before 21st June 2020. Malad, kindly come to page.
And 5,001 normal vacancies arose before that, within that period, new vacancies. And what are the setup school vacancy?
5108.
So according to you, 10,000 more vacancies
vacancies
should come within the fold of this advertisement. Very good. Yes.
Malad, I take your losses to the 3 documents, your losses. Kindly come to page 213. 3 of the paper book. Remember, paper book not the stay application. Malad, 213.
Page 213. Yes.
Now your losses will find this is updated 21st June 2021. Just Malad, I just place it, you have to be clear to your losses. It is notified for information of all concerned that the final vacancy list related with first SLST 2016 for recruitment to the post of assistant teachers at upper primary level of schools, except work education and physical education, is being published in compliance with the order dated 11th December 2020, passed by the Honorable High Court.
Yes.
And as per Rule 9(3) of the West Bengal School Service Commission selection list.
14,330.
Malad, your losses, total vacancy 14,339.
Yes. Then
Malad, your losses kindly come to page 230. Malad, kindly see the date of the letter, 11th August 2020. Malad, kindly be hereby informed. Malad, this is the lawyer's letter to the Honorable Chief Justice for assignment of the matters for constituting a special bench so that it can be heard, because this relates to thousands of vacancies, all that throughout the state. Kindly be hereby informed that the above named matter have been filed inter alia challenging the selection process for filling up approximately 14,339 vacant posts, upper primary level, in the year 2016. For the said 1433 number of vacancies, approximately 1,80,927 candidates made applications in the said selection process, which has been challenged by the candidates at different stages. So for more than 1979 read petitions, consisting of about 14,789 petitioners, have been filed before the Honorable Court. By an order dated 11 November 2019, Her Ladyship the Honorable Justice Bhattacharya was pleased to mark the first 3 matters out of the above mentioned 6 matters as heard in part, and the other 3 matters were assigned to the said bench subsequently at different times, before the normal functioning of the Honorable Court was disrupted due to the sudden spread of pandemic COVID-19 of the above matters, except read petition number such and such were extensively heard together at length by the Honorable Justice Bhattacharya on such and such date. But the hearing of the matters could not be concluded due to sudden declaration of the lockdown. Through the petitioner also has completed their arguments. In view of urgency explained below, the above matters were mentioned before the Honorable Justice Moushumi Bhattacharya, and pursuant to the same, the above matters were listed and were taken up for hearing on 7th August 2020, after he has been pleased to pass an order directing the matter to be listed for hearing on the next available vacancy. Kindly consider.
So what happened to that? There were her ladyship passed the order when?
11th December 2020.
What?
Now kindly see the second page, matlab the first two paragraphs. It may be mentioned here that though the final merit list have been published in the said selection process, with kind leave of the Honorable Court, counseling and recommendations could not be made due to subsisting restraint order passed in the above matters. It is pertinent to mention here that after initiation of the above said selection process, about 5,001 more vacancies have been reported to the Commission. Now, therefore, this is not newly set up vacancies.
What is the first line, Mr. Shah mentioned that though the final merit list has already been published, which was
that was quashed by the Justice Bhattacharya ultimately.
Okay.
So even before Justice Bhattacharya's judgment, these vacancies were reported to the Commission.
No, this final merit list was prepared on the basis of how many vacancies?
14339.
1/4. Yes.
Kindly similar this, kindly Malad, once again Malad, after the first three lines, it is pertinent to mention here that after the initiation of the said selection process, about 5,001 more vacancies have been reported to the Commission. But due to existing bar in the relevant, those vacancies could neither be included in the present selection process, nor a fresh selection could be Malad, initiated by the Commission. Due to the above pendency of the above writ application and subsistence of the orders passed therein, the process of filling up the post of assistant teacher in primary school level schools throughout the West Bengal could not be done. Therefore, Malad, this should be included. Kindly visualize the rules. Then your lordships, kindly come to page 232. Now, kindly take note of this letter, 15th February 2019. Subject allotment of 5,108 number of teaching posts in 1703, number of new set up upper primary schools in past graduate category. This is other than the 5,100 vacancies. Another 5,108
new setups.
New setup schools. Kindly see, this has been created in number of 1703 newly set up schools.
Yes.
But therefore, newly set up schools and the vacancies which occurred during the time should have been included.
Yes.
Now, your losses, just for a second, your losses, kindly consider the rules. First, rule 2, sub-rule P or sub-clause P. Now, kindly see the vacancy. Definition of vacancy. Sub-rule P of rule 2. Vacancy means a vacancy in the post of a teacher for classes of upper primary level caused by one, creation of new post.
Vacancy. Yes, yes.
Means a vacancy in the post of a teacher for classes of upper primary level caused by one, creation of a new post. But I first harp on this point, 5,108 vacancies, creation of new post. And that occurred even before, long before the judgment of the Justice Bhattacharya in 2019, 15th February 2019, the date, intimation. Kindly see.
Then what happens to those persons who have attained their majority within the 2016 to 2024? If all the vacancies are to be brought within this fold, then the entire appointment procedure will subsequently in future stand frustrated.
No. May I get your losses point first?
Hon'ble, due to pendency of the litigation, you are now insisting. Who is insisting? A person allegedly who says that I have been wrongly tested. I have not been given proper marks. We understand that submission. Manipulation is there. But Mr. Hon'ble, what is the basis of your submission? That for pendency of the litigation for which everybody has suffered, you will get the commission will now be asked that bring 10,000 vacancies more.
With all
then this application becomes frustrated. Then all will get appointment. No. Then your argument for manipulation, you need not go into it because today 10,000 vacancies are added. then the total vacancy will be 24,000 and odd, which includes all the litigants.
I tell you that. No, applications, my lord, 2 lakhs.
So what is the justification behind your argument?
My lord,
Manipulation we understand, but enhancement of vacancy, Mr. Channal, you have pointed it out to us. Kindly allow us to.
my lord, kindly, my lord, probably I will be doing injustice to my.
No, you will not be doing it.
I tell you,
you are arguing.
my lord,
You are arguing all
the
the
first impression of your losses might be correct, but it is not the correct impression.
No impression. We are asking a question.
My lord, I
No
tell you, losses
impression.
2016 process was started by the government itself in 2019.
Who are you?
But
Who are you to come
I am
and
the
tell it?
candidate. Suppose your lordship.
Who are you to come and take that point? You participated in the
Oh,
process.
my lord, I tell you, lordship, when? My lord, on the allegation, my lord, 2016 recruitment process advertisement was there, but the government kept tight over the matter. The first, my lord, the notification was issued for the into 2019. Therefore, my lord, the vacancy rule says the zone of consideration. I am affected by that.
Vacancy rule, what does it say? Creation of new post. You're correct. It is a new vacancy.
Therefore,
question is whether it will come within its folder.
My lord, first vacancy list is at 10:30.
Mr. Sannal, we go to the next stand. First reservation point.
This point, my lord,
you in reply you satisfy. We are not expressing any opinion. We are asking the argument of yours.
My lord, therefore, that's my lord. Therefore, the new vacancy list comes.
Yes,
the new
we accept that according to you, the new vacancy comes within the definition of vacancy, and as the proceeding, as you are publishing the interview list in 2014, you must take into
2019.
2019, you must take into account the new vacancies which has come into being. Straight and simple.
I tell you, logic is that I tell you.
We don't understand what is your legal right to draw in vacancies. You are not the person, only sole person participating in the process.
Well, number of candidates have come up. I am not sole. Number of candidates. Number of candidates come up. Well, the logic behind these rules.
Mr. Sannal, we understand manipulation, misincorporation, everything we understand. You have valid points and reservation is one of such points. We understand. But Mr. Sannal, litigation will never end. Today, one generation will suffer for the latches of the government and commission and etc. 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 What happens to the future generation?
I tell you, state after 2015 state, there has been no state in the state. So there is no available qualified candidates except those applied for. After 2050, without state passing, no one is eligible to apply. So after 2015, there has been no state in the state. So these are the candidates. Now 2015, 16 September vacancies, tentative vacancies disclosed. Rule says before publication of interview list, you have to publish the final vacancy list. Final vacancy includes newly created posts and all other vacancies. So I have the right as soon as you publish the advertisement in accordance with the rules. I'm not asking something beyond the rules. I'm asking something within the rules. This zone of consideration as a logic. Well, suppose your losses today, you losses prepare the panel for including creation of post.
We will ask you to point out your arguments argued before Justice Bhattacharya. You will satisfy us on that.
Yes, your lord, I will show your losses to that.
Yes.
Therefore, my lord, this is the vacancy.
213, 2230 and 232. Any other document you want to show?
230, 230 and 213 I have seen.
213, 230 and 232.
That's it.
Now, your next argument, Mr. Sannal?
Manipulation.
Manipulation, yes.
The first evidence. First evidence. 12 September 22. Your lordships will find one compilation of affidavit.
Yes.
Now, my lord, the first affidavit filed by the commission, your lordships, on 12th September, affirmed on 12th September 2022
in the present,
present appeal process.
that is here.
Yes, yes. That's in the bunch of losses.
You are showing us that affidavit.
That affidavit. This is in regard to manipulation of take marks or reassessment.
Can you give us the page?
Page your losses. Well, in the index, your losses will be getting it. First affidavit, serial number 6 in the index. 6, serial number 6.
Written notes of argument?
No. Well, and another bunch of documents, affidavits. তোদেরই জিনিস তোদের আর কি দেবো আমরা জজদের সুবিধার জন্য করে দিচ্ছি তো বিরোধীকে যদি সব সুযোগই করে দেবো হ্যাঁ একে তো জজ
আচ্ছা তুমি শোনো ওই যেটা বলছেন
এই যে পেয়েছেন তোমাদের দেখেন আমি বলি 15 সেপ্টেম্বর
yes then we continue tomorrow
এটা বার করে নি আছে সব আছে
we have heard Mr. Sharna learned advocate appearing for the appellants at length. Where is Mr. Bhattacharya has left?
No.
Sir.
Mr. Bhattacharya, if after Mr. Sharnal completes, if tomorrow
I am led by Mr. Mitro.
I am here.
All right. So tomorrow we are keeping at 2 p.m. Mr.
As soon as they finish it, I shall not take up.
Yes, he will take half an hour.
No,
He will take long time.
Oh no, he will not take it.
So kindly allows the addition of parties.
It's the matter for further consideration. Let us come back tomorrow.
হ্যাঁ যা
ঘুরে বেড়াচ্ছি যাও
ও তো এমনি হয়ে গেছে ভাই 3 দিন হলে হয়ে যাবে tomorrow কখন যে টাইমটা
করে দিচ্ছি স্যার করে দিচ্ছি we can, please give us a chart of the applications.
all application it is already in the
Application stage.
Item number 17 kindly cease.
17 and
17. Serial number 17 without list.
item number 17 and item number 37.
Those are the applications without.
Tomorrow, why don't you give us a list of those applicants so
Very
that our court officer can segregate it and keep it separately?
Fine.
We will consider that after
Fine.
the
As you lordship.
Yes.
because you, in the meantime, Dr. Patro will also take addition.
New applications 9 have been added. After the matter has become
Have you got the application copies of the new?
9 I have received. Whether there are more, I don't know. 9 have been served upon.
We have served. We have served mine.
No, we have served.
No, if it is
What is the problem, sir? You make a copy and give it to him.
Finally,
No, I am giving my copy here and now.
No, not here and now. You do one thing. Suppose you have filed 10 applications,
Mine.
give the numbers of this and 10 applications, you give copies to Mr. Dr. Patros Jr.
Very well.
So that
very-
either tomorrow or the
Yes,
day after we can take it up. And
Yes, as a lordship, please.
already 2000 odd candidate already added. এই একটা my lord, all the court order.
when was it added?
When it was heard previous.
Judgment of 4th December.
Can you, what is the date of that order?
4th December.
4th December 2023.
Till that, my lord, 92, scan 92 was there in the list. Thereafter, my lord, we have, my lord,
4th December, last application was allowed.
Yes.
Last December.
Yes.
4th December order.
December which year? The veteran litigants. Veteran litigants.
ঠিক আছে, চল। দেখিয়ে নেব। Regular display। লিস্টটা কি চারটাকে তোমার অনিন্দ এডিশন আপনার দিচ্ছে অনিন্দ শুধু তোমার গোলাম কথা বলে না
The cost titles will have to be amended and circulated.
Yes.
No, that they will bring the list.
Yes. No, no, we have already delegated it to someone. Will not, a list will be prepared by tomorrow.
In connection with which?
Yes. অনিন্দ শুনে নিয়েছো তো? Great.